ಹಲೋ ಹಲೋ ನಮಸ್ತೆ, ಯಾರು?
It's a lordship leave, madam.
Yes, madam. Just a moment.
Yes.
Yes, sir. Yes, the word, madam.
Serial number 59, madam. What is it engage me that today is inconvenient. Tomorrow you put your lordship help, madam.
Serial number 49,
No, 59. That case, there are 7 petitions.
59
by the management, 4 by the workman.
Yes, sir. George
I
Anthony
appeal for
Cruz.
the workman. I may request. Last time I was ready. They had taken adjournment for today. I was not knowing. Today is my personal inconvenience. My personal evidence is there. So could your lordship have it tomorrow? Tomorrow, madam.
Tomorrow we are dealing with the other matters, that is KEB and other roster matters. The labor matters would be taken only on Monday and Tuesday. Monday and Tuesday is the labor matters.
You'll have to have it on Monday, madam.
Tuesday, madam. Instead of Monday, it may be posted on Tuesday, madam.
Tuesday at 2:30.
Madam.
Is it okay, madam?
No.
Tuesday, madam.
No, I would appeal to your lordship to have it Wednesday, madam. Wednesday, madam. Tuesday, again, my personal evidence. High Court direction is there every day afternoon. I had to go and give evidence. I am sorry.
Wednesday, we have no problem.
Monday
no, but then Wednesday, Monday,
Yes.
Monday you take it, Mr. Mohan Kumar, Monday,
Yes,
2:30.
yes, madam. Yes, madam.
Monday at 2:30.
2:30.
Yes,
2:30.
madam. Great
Yes.
question. Great question.
Madam, may I make one submission, madam? Serial number 18 for dictation, madam, we have given proposal to Mr. Kuttappa for each workman 4 lakhs. He wanted some time for consulting his clients, madam. Therefore, it may be taken upon next week, madam. We have given proposal.
Mr.
No, 4 lakhs, Allah, sorry. That is a mistake. My God.
4 lakhs, 4 lakhs.
4 lakhs, Allah.
Yes. Yes, Mr. Kuttappa, how much is the amount they had offered to you?
Yesterday, I think, slip of the tongue, they told me for 4 lakh.
Then how much? Mohan Kumar, you should know how much is the amount. Now that you say 4 lakhs, you have to give them
I
4
will
lakhs.
take instruction from my senior, madam.
You should
Then
have
I
done
will-
that in the first instance.
But there is
Now
communication.
that they will not go back. They'll say they want 4 lakhs only. Now you pay.
There's a goof up. Could it be called on Tuesday, my lord? I'll talk to my clients.
Yes. Both the council submits that the parties are exploring the possibility of settlement. And release this matter on Tuesday for reporting settlement, if any.
Otherwise, we'll proceed.
Yes. You have already argued the matter, right?
Out.
Yes.
Attendance, if any, it was at number 6, then number 23 to 27.
4 lakh, ಯಾರು ಎಷ್ಟು ಹೇಳಿ ಬೆಳಗ್ಗೆ ಟೈಮ್ ತಗೊಂಡ್ ಹೇಳಿದೆ 4 lakhs ನೀನೇ ಕೊಡು ನಾನು ಕೊಡೋದು
Senior counsel.
4 lakhs ಆಗಲ್ಲ.
Senior counsel. Not here. Look, Tagad today. Yes. Serial number 29. Learned counsel Harish Pandari submits that HR Ranika, learned counsel for the petitioner is unwell. List this matter next week.
Number 8, then number 34 to 42.
34 only. Would it be called a week after next, my lord? I'll argue the matter.
So Kuttappa, you should be happy now. Respondent counsel is seeking for an adjournment.
Aye.
A joint request. List this matter week after next.
I will argue that matter.
Yes.
Page number 9, serial number 43 to 48.
Trainee matter. Call this matter after 4 weeks. A trainee matter, don't please ask the registry not to list. 38 also is also pertaining to the training matter. Now, what is the position now? It is referred to the larger bench. Yes. 45. You are appearing for the petitioner. At request of petitioner counsel, list this matter week after next.
Page number 10, serial number 49 to 56. Page 11, 57 to 59. This one.
Correct. Yes.
One more matter pending.
You have.
Total number 14, and given them the number and asked them to get it connected. There's an order passed.
Have you filed wakalat for the petitioner? So and so counsel submits that he has filed power for the petitioner. Registry to put up the same. It is submitted that DS Hosmet, learned counsel for the petitioner, is no more. Registry to delete the name of DS Hosmet from the cause list. Yes. List this along with. Yes.
One.
This is the matter for further hearing next week. Next week, further hearing. Please.
Next matter, number 1.
ಏನಾಗ್ಬೇಕು ಇವ್ರೆ? What is 47. ತಗೊಳ್ಳೋಣ. ಯಾರಿದ್ದಾರೆ ಅದರ್ ಸೈಡ್ ಅವ್ರು ಕಳ್ಸಿ. ಗೀತಾದೇವಿ ಹೇಳಿ ಅವ್ರಿಗೆ. ಗೀತಾದೇವಿ ಬಂದಾಗೆ ಹೇಳಿ. Yes.
Number 1, Praveen Kumar.
You take notice for respondent number 2 and 3. It is a show cause notice. You file your objections to that. Yes, CGP to accept notice for respondent number 1. €3. Nanda Kishore is directed to accept notice for respondent number 2. Serve the petition papers on the learned counsel. This matter on Monday.
Then number 2, Michigan N.
Which is the connected petition? Read please.
It's 62A or not. Because we have an ITGT certificate, therefore we now come under 82A. But we don't purchase power from DISCOM. We purchase power from green energy sources. Now, DISCOM also small quantity. The difference between power that is purchased from outside and this is.
That is concession and the original. Concession is there? Is there any concession?
The appropriate tariff is changed now. Now we are asking for back billing for year 2022 without taking into consideration the most important thing. That is not that all the power is sourced from green energy sources, not from DISCOM. But they do back billing for green energy.
There is no conditional order for the.
The concession tariff in PPP, what time it comes to be 1. When query is so submits, there must be an interim order for the condition that the bill raised the authority. As for the concession tariff, must be paid to the village.
The power service is to continue. So the stay is only in regard to the operation of the order, and you have to continue to pay the concessional tariff. Who appears for the respondent, who has to take notice? Devraj. He appears for 1 and 2, and 3 notice has to go. HV Devraju, learned counsel, is directed to accept notice for respondent number 1 and 2. Petitioner counsel to serve the petition papers on the learned counsel. Issue emergent notice to respondent number 3. Learned senior counsel Dhyan Chinnappa, appearing for the petitioner, submits that in identical matter.
Same order. Same order.
It's against identical matter, right? Identical.
Which one of the 3? Inspection and right of inspection.
Submits that in WP 16733 of 2023, referred by the respondent number 3. The ordinate bench of this court has granted an interim order of stay of the operation, subject to the condition that the tariff schedule HT2A. In order to maintain parity, the interim order granted in WP 16733 of 2023 will also be granted in this petition. And appropriate.
We pay the appropriate tariff.
The impugned order, impugned demand notice dated 19 January 2023.
772.
Is in 19/20/23.
interim order is 7/7/23 reached 8/51.
Okay. But the interim order prayer you are seeking for 19 January 20.
7/7, 19/1 and 21.
So 3 orders.
A, B and E.
The interim orders at annexure A, D and E dated 7th July 2023, 19th January 2023 and March 21, 2023 is stayed till the next date of hearing, subject to the petitioner paying, continuing to pay the appropriate. What are the charges? Concessional tariff charges?
Appropriate because one of the major demand for the regular tariff, I pay the regular tariff.
Appropriate consumption charges, huh?
Appropriate tariff.
Appropriate tariff charges. Yes. Password. It's password. This, what is this? Next matter. Huh. Password. What is this process to whom? At request of the petitioner? No, review petition. Why was notice issued? Huh? Yes. A week's time is granted to do the needful. There's no appearance on behalf of the petitioner. A week's time is granted to rectify the office objection raised in I number 1 of 2024. Or representation, a week's time is granted to do the needful. To rectify the office objection based on I number 1 of 2024 and 2 of 2020.
Number 8, Yogi
Uncovered. A week's time is granted to do the needful in respect of unserved respondent.
only the patient.
All this. Yeah. For a property that was audit during our mistake. Complex of and summons.
You have served the hand summons on the respondent.
At the end of the day,
Yes, petitioner order should go. Petitioner counsel submits that the due to inadvertence, the petitioner could not serve the hand summons and take notice to respondent number 24 and request for a day's accommodation. At request, the petitioner is granted 2 days time to comply the order dated 20th 8, 2024. Yes. Now, that also you have not filed. 2 days. So we said compliance of that order. 2 days. Huh? You have?
Thanks for KIDB.
So KIDB has also issued. Now, who is remaining now?
Thinking about Victor's 11 Workman, you know. Victor.
See, you have reduced from so much, you have come down to 11 now.
Someone is 7.
No, I guess to the No, now already the KIDB test. Then what remains? So see, this is like a lady showing the age as constantly one for a long time. It never. Correct now. If you would have. See, totally they were 32 the workmen.
52 only 11 have been taken.
Hmm.
11 plus 2, they are the only people who have to take.
Now 42 were remaining. Then others said they will take. If they have committed.
The observed in our
Litkar, who appears for Litkar? Litkar is the one 24, I believe. Respondent number 20.
for MEA, they have a passport. So instead of the other organization, they want to take it up. Litkar is having 11 years.
Litkar, who appears for Litkar? Who is the counsel? Respondent number 15, yeah, not it.
Muttanna? Gopal for R15.
TP Muttanna. Putting Gopal for 15. Who is Gopal? Counsel Gopal.
Number 9.
So KIDB, you have filed your affidavit so that you file an affidavit also that you have already. Respondent number. See, you are appearing for 9. Yes. When did you file an affidavit? So you don't dispute that they have.
Gratitude from KIDB.
27. So we can drop the proceedings against the KIDB. And who has again taken now? No, kindly give a memo stating as to who have taken the workers. Allah, see, we have to see so many affidavits now. Instead of that, if he files a memo to that effect, we can always say that the proceedings against, yes, that can be closed instead of looking into all the affidavits and wasting the course. So you file a memo. Petitioner counsel to file a memo indicating the work, the status of the workmen employees being taken by the establishment, by the respective establishment, by the next date of hearing. List this matter on Monday. ಗೊತ್ತಾಯ್ತಲ್ಲ yes
Number 10. Adjudication.
Yes, what is this wakalat? Non-filing of wakalat? You've already filed wakalat in the connected petition. Via data, then it counsel submits that he would file wakalat and request for 10 days time. At request 10 days time is granted to file wakalat. Yes. List this matter on 17th.
I appear for appellant.
Yes, Mr.
My lord,
Appellant.
my
Number
lord,
11. Prakash, it's serial
Yes.
number 11.
Oh, sorry, I'm extremely sorry.
Nanja Reddy, what is this? Annexure N, you know? ಏನಂತ office objection? What is the office objection? Is original alva? This annexure N is not original. 57. ಇದು ಒರಿಜಿನಲ್ ಅಂತೀರಾ ನೀವು? ಇಲ್ಲ, this is not original. This is not original, right? N. L is signed. N is not original. You have to comply. Petitioner to comply the office objections by a week. L. Yes. Hmm. 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 Have you paying the consumption charges on? Temporary connection has been cancelled, and you have to apply for the permanent connection. Now they have disconnected your not at all. Who takes notice for the respondent? H.V. Devraju is directed to accept notice for respondent number 1 and 2. Petitioner counsel to serve the petition papers on the learned counsel. Now you are challenging annexure L and annexure N as well. Annexure L is permanent, and that has been rejected. And now, as per annexure N, they said that they will disconnect the electricity supply. L. There shall be a stay of the for the proceeding pursuant to the order dated 21/8/2024, passed by the second respondent at annexure L till the next date of hearing. You comply the office objections. At least file a dispensation and delivery order. Who has filed this all applications? I-1 of 2017,
That
B
is,
of 17.
I filed one for a direction to pay 17B. It's not paid since 2018, my lord.
Was there any interim order by this court?
Yes, there is 17 to comply with the 17B wages. Since 2018, it's not been paid.
2018.
18.
They have paid some DD amount.
That is after that, no, nothing is paid.
When was the order for ordering 17B wages?
My lords would get it precisely on 1/8/2014. Interim order. 30th day of July 2014 is the order staying the operation of the award. Then it's not paid since 2018.
Yes. And now this is an application filed by you seeking direction to pay the 17B wages. And then next,
Exactly.
I-3 of 2017.
Now,
Of this-
another one is filed by Senior Counsel Nandakumar as he then
Hmm.
for deletion of the name of second respondent. I didn't file that.
Who are you? Who are you?
Me?
Ah. Yes. So we'll hear this application along with the mail, along with, no, we
But
have to hear it, right? We have to.
17B
Ah. Ah.
has not been paid since 2018.
Ah. Hmm. So first matter you have filed wakalat, right? In first matter. Petitioner counsel, petitioner, Padma Uttur, learned counsel submits that the petition papers in WP 17920 of 2014 has been received by her today. Ivat receive aitalva? Would has not yet been received by the petitioner as the earlier counsel. Narsimha Holla is no more and she was directed to take notice. Huh? She was directed to take notice in the present petition and submits that she would argue the matter on the next date of hearing. At request, list this matter on 10th.
10th,
10th.
17B application.
Ala, she's got her problem. She's got not. She doesn't have the file with her.
Oh, I.
Mr. Kamala Charan. Please kindly show the square in that application. 17B. So whatever is there, there is an order passed by this court. They have to. From the month of right from the month of February 2024. Why are you asking the parties to stand here? Ask them to sit. Sit. Put for it. So the respondents are filing application. Respondent Workman have filed an application to order restoration but continuance of the interim relief paid to the respondent since past several years at the rate of 4,600 per month based on the order dated 8/2/2019 under section 17B of the ID Act 1947. It is the case of the respondent Workman right from month of February 2024. The 17B wages have been discontinued. Petitioner counsel seeks time to verify the same. At request, list this matter on Monday. Yes, what is this amendment? No, what is this application? What is this application for what? What is the amendment they have sought? in this writ petition as well. So how can, so you have any objections for, you have answered already now. What is that remaining now for the council to answer? Respondent council submits that so and so council submits that Jayalakshmi P. Then council on record is unwell. At request list this matter on Monday. 9/9. Harish Bhandari. What is the direction? In 17B, na? ಆಮೇಲೆ ಸ್ಟೈಫಂಡ್ ಅಲ್ವಾ ಅವರು? Now, there is an order passed by this court. There's an order passed by this court on 14/11/2019. Stay subject to reinstating the respondent workman forthwith and paying the stipend. Stipend anta madidare and would accrue on such reinstatement. ಅದಕ್ಕೆ ಇದು vacating ಹಾಕೊಂಡಿದ್ದೀರಾ? This order has to be vacated or modified. Alandra, this order stands. How can we even look into that? Yes. Yes. What do you want to say? Monday. Yes, Mamta. No representation. All this matter after 2 weeks.
My lord, I appear for appellant. My lord, this matter, your lordship kindly recollect. The matter is settled. My lord, I am a tenant and I suffered a decree of ejectment in a suit filed by the first respondent. My lord, last occasion we have informed the court that matter is settled. That is, my lord, he is ready to grant, my lord, 1.5 years time for me to quit and deliver. And I am agreed to pay, my lord, rupees 5,000 per month. That is how, my lord, matter is settled. My difficulty to report the settlement is one. My lord, the fourth appellant, my lord, the respondent, appellant, my lord, is out of station. He is in, my lord, Switzerland. And the other two, my lord, the sisters, they are not available right now. My lord, therefore, my lord, I require time, my lord, one to make an application, that is joint memo. I have to get this, my lord, power of attorney by the others who could not immediately available. And also to file undertaking affidavit. My lord, I have prepared, my lord, the undertaking affidavit of sixth appellant who is actually in charge of this building. My lord, I have informed this to my learned friend also. This is the difficulty I am facing. My lord, there is no question of going back from, my lord, the settlement. We are bound by it, we go by it. But I want, my lord, time till 14th.
You filed the affidavit of appellant number 6 who is present before the court today.
Yes.
And then
yes,
you
Lord.
file in respect of other appellants on 14th.
Yes, my lord, but I can't file it, my lord. The fourth appellant, he is in Switzerland.
No, appellant number 6 is present before the court.
No,
right?
that 6, my lord, I file it. My lord, I filed the
File it
6th
today.
one.
You filed
Yes,
today appellant number 6. And
Yes,
insofar
ma'am.
as other appellants, you file by 14th.
Oh, bless me. I can do that.
So we'll pass over, you file an affidavit. You ask the affidavit of the appellant number 6.
Yes, my lord. Yes, my lord. Your lordship kindly have it 2:30, my lord, so that I can.
2:30.
I can send. Okay.
So that they would be binded by the terms of the affidavit.
Yes. My lord, even otherwise you are bound by it. You will not go back. from
No,
what
no,
the
but
settlement.
we never know. Let them file an affidavit.
Yes, certainly. We'll do that.
Question 19. Chandra, please.
Tara? Yes. Yeah. Hmm.
The priority starts from the 30s. The sixth law at page 18. They read the division there.
Hmm.
It is not science operate secret under the act. Your right to financial sector is the transfer of this economic subsection E of
Yes. Yes.
From the spelling about the omission
Yes, yes.
omission to obtain sanction. Previous sanction of the defeat of the original sector. If not, rental side or bank of 9, 6 or 7. So that so clear to 7, 8. But as such transfer can be regularized the gain to the domain and amount equal to 15 times to the other. Right. So the transfer you have to pay. That is not he gets it regularized only at the payment of 15 times. See the Indian business to regular. That is not they are seen the amendments like previous after opening this but that transfer of payment equal the amendments would be brought for a period of 2 years. So, the amendment that it's already of your right area that is that in what we did unless it came from all and that any person thereof shall be limited. You can take this science in here. There are one minute. Like these nothing to issue that why? That cannot be this board directed that it becomes a paragraph. That's what the order of event of grade and one
Yes, yes.
6 then the authority will have to regularly say in favor of the alienee by collecting the amount, so that the alienee is the particular alienee. Alienee by collecting the amount equal to 15 times the interest rate. And if the application for the income of the amount successful, then the authority will proceed with the eviction proceeding.
Yes, when, and if the application for regrant was
Yes,
not,
he has to make an application.
no, no, yes, yes, yes.
He has to make an application for regrant by paying, by collecting amount equal to 15 times of the asset. Then he has to make an application. Then thereafter he has to pay 15 times along with the application, that is the legal costs. Therefore, whether he has
So
not-
according to you, the merely an regrant application filed by the holder of the land would not inure to the benefit of the petitioner.
unless he pays the 15 times.
So your contention is until he pays 15 times,
Pay 15 times with the application.
that the regrant in favor of the holder would not inure to the benefit of the alienee. The benefit would be available only if
He makes an application along with 15 times the asset.
and files application for regrant.
For the operating time machine.
Yes.
If two statements are referred to, I can just consider that in basic. In basic. These two matters are referred to by judgment. In this side, by judgment, it has been upheld. It was upheld. Read the health minute at page 60. Well, and the union bench is going to follow the decision of the coordinate single bench. So they are also of this Indian bench on the facts of a decision.
Where are you reading? Where are you
I
reading?
read that in the section.
Head note
Where
or
those are not included.
head note pad any paragraph or para 20. 112. That's 24. 24. Hmm. Yes, yes. Para 24. Yes.
It was a matter of observation of the difference in the rates. It is one three on the remote or has already stated it. So we'll see the effect was not going into it. If you are going to it, we are glad by the organizations. If you know the above, we can As already stated, and the reference is not made as a only that is the Single player, not agreeing with the other bills, they will not be considered. That's the consideration.
Appropriate. Now, see, the question here is, there is a sale which is not disputed. That is, after the coming into force of the act and before the Amendment Act 1978, there is a sale, that is 1966. The Lakshmana's case, the Lakshmana's case, Bashir Ahmad's case, and this Haleshappa's case all refer that all the sale deeds which are executed between the Principal Act and the Amended Act 1968 would not be held to be null and void. Is it not? Correct. Whether in that fact, whether he had made an application or not, but nowhere in the entire judgment it is not available that he had made an application. The Alini had made an application for regrant and he had paid 15% assessment. Nowhere it is there. It is not there. Is it there? Anta nee heli. It is there.
In our paid application and paid assessment in the finding of the classes of acknowledgement.
Illa. File court and the Tahsildar say that he is not in possession.
That is the finding of the Tahsildar as well as the lawyer.
The Tahsildar and the First Appellate Court goes on the presumption that he is not in possession of the property and he is an unauthorized holder. But that is not the law. When you look at the entire judgment, though there is a passing reference to the 15% of the assessment and all that, but what it has said in is 1966 to 1978, 1963 to 1978, there is a sale that has to be protected or it can be taken.
Bad finding the thought to say, oh, there will be first. The officer has to appreciate. First, it is not calculated by them, and I have 50%, therefore the reverse is government. Even when they say, written application, it requires further inquiry by the review authority. It is not an automatic.
When a holder makes an application for regrant, the application has to be made by the holder itself. So there is no provision in the act which says that Alini has to also make an application for it. That is how, that is correct. So when a grant is made in favor of the holder does not dispute that there is an alienation in favor of the third party. When there is no dispute about alienation, correct. Now, he may say, take a contention that there is no sale deed or rather he has not executed, that would be something else. Now, in this case, he has admitted the sale deed. As on the date when he was seeking for a regrant, there was a sale deed in his favor, in the favor of the petition. Nowhere he said that there was no sale deed or anywhere. The Tahsildar on his own assumption, the Tahsildar of the year 1982, on his own assumption, said that the petitioner is not the sale deed executed in the name of the petitioner is to be treated as null and void as the land resumes to the government and the grant has to be given in favor of the respondents here. So according to you, there is a rider. So in light of his not paying 15% of the assessment, full assessment value, he is not entitled for.
Not an anchorment accepted. The application. The term is fixed. By law, whether you put the other requirements of the act. Something is mandate.
No, that was not the question. That was not the question in Lakshman Gowda's case or Bashir Ahmad's case. Because possession. Yes. No, now we have understood the. No, now we have understood that there should be a rider. Okay, we will wait. We will see. Yes. That and all you have argued. Facts ಎಲ್ಲ ಗೊತ್ತಾಯ್ತು. Facts nalli they have not challenged that they have not challenged before the appellate court. That was held by the division bench of this court, giving liberty to them to file an application before the Tashildar about the sale deed. So that single judge observation has been diluted in writ appeal. Now that you can argue it. No, it is already diluted in writ appeal. Huh. No, yeah. No, that is not the question here. That is not- No, single bench order was challenged in the writ appeal. Division bench held, no. We can't accept this submission at all. But it gives a liberty to them to file an application. Gives a liberty to the petitioners to file an application before the Tashildar. Alva, is it not? Dilution ಆಗ್ಬಿಡತ್ತೆ. No, now you cannot take a contention that in the writ petition there is an observation that the appellate he has not challenged the order of the grant which held the sale deed to be treated as null and void as the writ petition court has held so. The matter should be referred to the larger than that would not arise. That cannot be a submission.
Even if the statutes do not fix a time for interpreting the thing, that should be done within a reasonable. It is not in a greater course applying the person. It applies to a statutory authority is supposed to implement the law. He has to exercise that right with a legal right. If that applies to a very great court, the law.
Yeah.
And the question develops the government for them.
According to you, that is the main contention. Let us not look into what the writ court did in that matter is. No, because the submission was in light of the order of the writ of petition court, this matter has to be referred to the larger bench. I don't think that is acceptable. We should not deviate from what we are actually into. We are. Yes, no. We should be making submission which is relevant to the facts of this. See, this makes the court to go on. This makes the court to go into a different direction. Yes, rider is to the assessment, the payment for. No, we understood that. No, the question is whether the petitioner, that is the alienee, has to pay 15 times of the assessment to seek regularization in spite of the grant in favor of the holder. The question is that. Oh, just a moment. Just a moment. The question is the second, whether the alienee has to make payment of 15 times of the assessment for regularization of the transfer sale when the holder was re-granted the lands after the Amendment Act 1970. No, you just answered this question now. The 15 times they say, in light of the judgment of the Lakshmana Gowda, Bashir Hamad, and the full bench of the score, wherein it said that the alienee has to make payment 15 times in order to get a regularization of the lands purchased by him, in spite there being a regrant in favor of the holder. So that is now the question, because in all the judgments which you have referred to, there is a mention about the transferee, that is the alienee being paying the 15 times the assessment for regularization of them. So there is some observation in all this three judgments. So you have to enlighten this court on that as well. You need not go for a grant. You need not go for a grant. They have no dispute that the grant has to be made in favor of the holder. The question is only 15, only your confirmation of sale in your favor would be only on payment of this 15% of the assessment. Only that question. Please. Section 40. Section, the relevant sections are section 4, 5, and 7s. Eviction. So that would not. So 4, 5, and 6 of the Act. Yes. Yes.
Of land resumed under section 4, holder of the limitations.
Correct.
All these criteria which are described under the section are so far as it relates to the holder of the office, who is entitled to a
Yes.
Okay. The judgment of
You read that section once. Section 5.
relevant person would be
No, read the entire section.
clause 3 of section 4.
So what does clause 3 say? Subject to the provisions of section 5, section 6 and section 7. All the land granted or continued in respect of or annexed to a village office shall be and is hereby resumed and shall be subject. So under section 4, there is a resumption. Section 4, subclause 3, there is a resumption first. So when there is a resumption, the regrant comes. Correct? Is it not? A land resumed under in cases. So what is 6 and 7?
Authorized holder. Regrant of land resumed under section 4 to an authorized.
Now who is an authorized holder? Possession.
Title to the property by way of the valid sale or gift.
So will you be an authorized holder?
For sure, the honorable dishonorable court's order, I am not entitled to seek regrant by myself.
That is
Therefore, in
understandable.
case
So that is understandable. Next.
Not falling under section 6 and 7. I am not an authorized.
Correct. Be granted.
Holder of the village office.
Yes. So the holder will be given. Yes. Immediately.
Prior to the appointed date, hereinafter payment by or on behalf of such holder to the state. The occupancy price equal to 3 times in the case of holder of inferior village, 6 times in case of holder of other village offices. The amount of the full assessment of such land within the prescribed period and in the prescribed manner, and the holder shall be deemed to be an occupant or holder of a royal banda within the meaning of the code in respect of such land, and shall primarily be liable to pay land revenue to the state government in accordance with the provisions of the code and rules and orders made there. And all the provisions of the code and rules relating to inherited land or property land are subject to provisions of that. So, section 5, subclause 1 states that it is the holder who has to make the payment and in a manner. Now, this manner, if you not to be paid, there are rules that are annexed to the act.
Yes. Yes.
Time and manner of payment of occupancy price under section 96. The occupancy price therefore to section 76 may be paid in the level for the equal annual first to be paid within the level of repeating the amount of the Now this time period is prescribed specifically for a regrant under section 5.
Yes.
Therefore, my humble solution is this would be applicable for the application made with the respondent. And this payment schedule or the time limit prescribed under the act is for a person who is the holder of a village office seeking for a regrant under section 5. Therefore, that clause 1, the 3 times and the 6 times amount and the prescribed time period.
Where is that 15 times?
That third is by way of the judgment. That also in section 5 as well. Clause 3. Attention. The occupancy or the royalty part of the land, as the case may be, regranted under subsection 1 shall not be transferable otherwise than by partition among members of the two joint family for a period of 50 years from the date of regrant made on or after the date of the act.
That is after the regrant.
That such occupancy or the royalty part in respect of the land granted to the holder of this the enfranchised income shall be transferable with the previous sanction of the deputy commissioner shall be granted on payment of an amount equal to 15 times the amount of interest. Now, this would also not be applicable.
This speaks about provided that such occupancy or the right to any patta in respect of the land.
Yes.
Therefore, the section does not prescribe any rule or liability on me to pay the 15 times.
So it only says the price to be paid, occupancy price to be paid by the holder, 3 times in case of inferior land, 6 times in case of.
Section does not impose any duty on the alienee to pay the said prescribed assessment. However, I may draw your lordship's attention to the judgment of Honorable Court.
Yes. Now come to the judgment of Lakshman Gowda and. Yes.
The observation directly drawing the lordship's attention. Observation at para 108.6.
Yes.
Para 77.
In this case, previous permission was not taken. Previous permission of the deputy commissioner was not taken. So admittedly, it is not.
Para 77.
It's just. Yes.
Para 77. The object.
Yes. Correct.
Thus, imposing the restriction on alienation of land by the grantees under the said provisions, the legislature did not intend to prohibit totally the grantees from alienating the regranted lands.
So there is a benefit given to the purchaser. That is
the object of subsection 3 of section 5 of that act, which was made applicable to the subsequent alienations by all types of grantees, was to collect higher prices for the land to be granted if the regrantees wanted to have the right of alienating. Hence, permission to obtain previous sanction of the deputy commissioner, the original subsection 3 of section 5 act did not, in our opinion, render void transfer of the land regranted under section 5(6) was prior to 1978. But such transfer can be regularized by paying to the government an amount equal to 15 times full assessment.
yes.
Now, this has been further interpreted by this honorable judge. You find that para 30.
So the Lakshman Gowda case said, yes, the alienee have got a right. Alienee have got a right. And if there is no previous sanction from the deputy commissioner, the sale in favor of the alienee would not be rendered void, but stating that subject to the alienee pays the amount 15 times of the. So this is how the Lakshman Gowda's case. Para 30. Page number, can you tell the page number, running page? 58. Para 30. Para 30. Yes, that is what you read on that.
Indication of regranted service in your land during the period 63 to 78 valid and permission for sale is only a formality as a deputy commissioner was bound to give permission on payment of an amount.
So now in this case, is it an amount of 15 times the assessment paid? So you have not paid. Is it the 15 times of the assessment to be paid by the alienee or the holder?
It is not clear.
No, judgment says, it is the alienee. Alienee. Yeah.
I read 77 of that.
Ah, you read.
77. Paragraph again.
Correct. Alienation of re-granted service in arm land during the period of 1/6/1963 and 7/2/7/8/1978 is valid. So your sale is valid. And permission for sale is only a formality as the deputy commissioner was bound to give permission. So that is also goes on mere payment of an amount equal to 15 times of the land assessment. So there is a land assessment which has been valued and 15 times has to be paid. There comes the question. Yes, sir.
What I already read. Yes.
But your arguments were very impressive for the reason that this court all the time believed that the 15 times of the assessment has to be paid by the holder.
That's not the submission is. If the lordship are going to read that again, it is the only object of subsection 3 of section 5 of that act.
Which one you are reading? Correct. Object is to give you a relief, but then you have to do something for that. You have to do something for that. You are given the benefit because there's a sale in your favor, but that benefit would be available to you only if this is.
Law imposes a duty on the apply the procedure prescribed or the time frame prescribed to the holder seeking a regrant. There is no manner in which I would pay that.
Then when will you pay it?
I need to pay now.
Not
When
now.
I go before a Tahsildar, just like I come before this court, there is a stay order.
Then you should have done it at the first instance itself. First instance, when you had approached the Tahsildar, first round.
I come before an appellate stay of a trial court order. The court will pass an order stating that you are given the benefit of stay subject to payment of 50% of the decretal amount, 3% of the execution order.
That is not applicable.
Manner. I go before an authority. Yes, the authority tells me, yes, this your regrant for the benefit is passing on subject to payment of. I'm willing to be there. Before that, there is no manner in which you have to deposit the money.
All the while you were agitating before the court, even before the Tahsildar in the first instance only, when that was when you approached this court in the writ petition, you were placing reliance on this Lakshman Gowda's judgment and the Bashir Ahmad's judgments itself. You were aware that you had to pay this 15%, 15 times the assessment. You did not make any efforts at the first instance itself. Perhaps you could have taken a ground that you could not pay the amount, or rather anything would have been taken.
It's not that I am not willing to pay that.
No, but then that was not paid. That would be regularized only on the payment of. Yes. So there is, according to you, there is no manner prescribed.
No manner prescribed. The authority was paid. Like the rule 4 describes a manner in which the holder is to pay the amount.
Yes. Yes. So there is a thin line of distinction in this petition, whether you were to pay this amount of 15 times the assessment within what time. There has to be a rider for you also. Within what time you have to pay that amount, not after all these years, right?
Subject to legal. Sorry, subject to the benefit possible. Information.
So when was it? You read that now. There is a prescription, or rather there is a time limit for the holder to pay the amount, that is 1992. At the most, even you would have paid that amount by 1992. Allah, is it not? Allah, is it not?
Information, me approaching the authority beyond that time.
When did you approach the court?
2010.
2010. Yes.
Therefore, there is no feature, there is no manner in which I would limit that amount. Unlike procedure prescribed. After 1992, there is no manner in which the holder.
After 1992, there is no time limit. Limitation cannot be applied here. Is it not?
Therefore, my situation where I will deposit that amount, only once my land is confirmed, deed is confirmed.
Say once there was a regrant, 1982. For you, the right accrues at that point of time itself. Even you get a right in the property of the regranted line in the year 1982 itself. 82. When there was a regrant. Not earlier nor after that. So it is at that point you do. So when accrues. 1982 to 2010, quite a difference. Correct. There is no limitation, but then that cutoff date of 1992, which was given to the holder to pay the 6 times the amount or a lump sum. Regrant. Regrant. So that would be applicable to you also.
Section 5.
Understood. No, that is absolutely correct.
Is subject to that. Same way, my information or seeking benefit from the regrantee as per the order of the Honorable Apex Court. Sorry, this Honorable Court. This is subject
the 15 times.
As the lawyer pointed out, 1992, right? 1997 rules. This comes into picture in the Bashirama judgment in 1994. Of this Honorable Court, which states that it is a mere formality and that Deputy Commissioner could not have refused to do it, as it is a mere formality, and he is bound to confirm my standing and enter my name in the regular records. Therefore, I approach the authority, and when there is no manner in which
so according to you, the non-payment of 15 times equal of the assessment would not debar you, or rather would confirm your sale in your favor? No, what is your charge?
Law says that it's the confirmation of the state. It is subject to payment. I am willing to do it before any authority. Yes. There is no manner in which the act or the law prescribes or the decision of this one states that the alien is supposed to go before the deputy commissioner, deposit the amount and see. That is not prescribed under the
No, regrant. You cannot make an application for regrant. Regrant has to be made by them. But then if there is an alienation in your favor, then you have to pay this 15,000 to give away the permission which you are required to be taken, which they had to require to be taken from the deputy commissioner.
May I just call
Yes.
77. The object.
Correct, absolutely right. The object.
To collect higher prices for the lands regranted if the regrantee wanted to have the right.
Wanted to, Andre, afterwards, that is in pertaining to afterwards, wanted to have the right of alienating such lands.
So it says that if the regrantee wanted to alienate it, that could have been the object of the act was to collect higher amount. Hence,
no, this is insofar as if they wanted to sell the property, then this is the thing. They have to file.
Once of that amendment, after the amendment, if they want to sell, they cannot sell because the law prohibits them from selling. Of paying higher amount and getting permission. That could not be permissible under law because the amendment prohibits that sale. So, I was to collect higher prices for the land regranted.
the regrantee wanted to have the right of alienation. Hence, the omission to obtain the previous sanction did not enter a void of answer, but such occurs in the regular execution. Now, if this were to read quickly, if the regrantee does not wish to entitle me for the benefit that I am entitled to claim under law, and he chooses not to pay 15
No, no, it is not he. It is you for seeking for regularization. Ah, yes, yes.
to collect higher prices for the lands.
That is one part. There are two parts in this. There are two parts. The only object of subsection 3 of section 5 of the Act, which was made applicable to subsequent
Alienation
application,
by all types of regrantees
was to collect.
higher prices for the lands regranted if
the
the regrantees wanted to have the right of alienating.
Correct. Then the next portion. Hence, the omission to obtain the previous sanction of the Deputy Commissioner under the original subsection 3 of section 5 of the Principal Act did not, in our opinion, render a transfer of a land re-granted under section 5 or 6 or 7 of the Principal Act prior to 7/8/1978, but such transfer can be regularized by paying the government an amount equal to 15 times of the full assessment.
They draw lots of attention to the same thing.
Ah,
Draw the distinction between the old act and the
correct, 39.
old act is the logic of the date.
Yes, yes.
5+3. There is a table of
Which is that page number of
9.
page 39? Yes, yes. Para 39.
Table.
1/4. Table.
Next, the table. 5 subclause 3, which is applicable for a holder. The occupancy or the royalty quota of the land. Now, it is not occupancy, it is not royalty quota of the land. May be regranted under subsection 1. Sorry, may be, regranted under subsection 1 shall not be transferable otherwise than by partition among members of previous sanction or DC. And such sanction shall be granted only on payment of equal to 15 times the amount of plus. Now that is how section 5/3 stood before the Amendment Act. 5/3 in its entirety is applicable to a holder of a village office.
Yes.
Then, I just draw your attention to which reads as occupancy or the royalty quota of the land may be regranted, which may be regranted under subsection shall not be transferred. The occupancy of the royalty quota which is regranted shall not be transferable unless it is payment.
That was prior to amendment.
Prior to amendment. What this judgment stated is that in paragraph 77, read with the previous subsection 3 of section 5, its entirety would mean, does not, in my respectful submission, does not mean that the burden should be cast upon the aliener. Because subsection 3 of section 5 imposes the liability or responsibility on the aliener, the holder. And section 5 in its entirety is applicable to holder. And subclause 3 also speaks about holder.
Yes.
What dishonorable court in Lakshman Gowda judgment is not change the position of law. Instead, what dishonorable court find is that though you have sold it without the sanction of the government, the purpose was not to prohibit you from selling. The purpose was to collect higher revenue from you for having made that sale. Yes. Therefore, when 5 subclause 3 read with paragraph 77 and paragraph 30 plus A of state that firstly the sanction of DG is a mere formality and it has to be given, subject to payment. And 5 subclause 3 and para 77, it speaks about if the regrantee wishes to alienate and section 5 clause 3 is applicable only to a holder, the amount in my respective subsection is the duty of the holder. Notwithstanding any of these things, if this honorable court opines that it is my duty to pay, I am still willing.
Yes.
Addition to that would be that there is no manner in which I have to approach authorities, how to approach authorities, what time frame I have to approach authorities, who is the person who have to deposit money before, under these things are there. And section 5 does not apply to me, and para 77 is discussion of section 5 of clause 3. And the previous section before the amendment also spoke about the duty on part of the holder to pay that amount. Judgment does not say that the duty is transferred to the aliener.
The para number 30 of the Bashir Ahmed's judgment, wherein the guidelines have been referred.
For sale is only a formality, as the deputy commissioner is bound to give permission. Now, as per this judgment itself, the law says I am not entitled to seek permission. I am not entitled to seek permission or regrant. The question of deputy commissioner granting me that permission would not arise. Therefore, even today my submission is that they are liable. However, contrary, if this court were to take contrary view, telling that I am the one who suffers, I am still willing to pay.
All have completed their arguments.
Purchases. He wants to have it done, it's regularized. Regularized means it is a judicial act or a quasi judicial act, which is not an act of the
Yes.
And another aspect is, three imposes an obligation on the aliener, whole section.
Yes.
Then you are also, I don't perform. Then what happens? I say it becomes invalid, not regular. Then you are also supposed to say that it becomes an unauthorized order. You are also supposed to say, appreciate. Section 5 clause 3 imposes an obligation on the aliener. I don't confirm. Then what I will say, sale is not regularized. That means he won't get a installment as the that is effective, he will not be recognized. He want an installment by bidding. Simple question. You perform, you get it. If it is obligation on me, and there is I don't do it at all. And why do you regularize this? Regularize, the quality initial act is not an automatic. If I seek a permission, either the transferor or transferee seeks a permission of the DC for purchasing, it is automatic. But paying a 15% is regularizing the quality initial act is not.
Yes.
This Lakshman Gowda case was delivered in 1980 was.
Yes, 1980.
Judicial portion of 77. Said which of the above rival contentions would be accepted where the examine the object of original once village office is abolished, tax attached thereto cease to be emoluments. No public policy was. In our opinion, in prohibiting transfer of such lands after abolition of village offices, under original subsection 3 of section 5 of the Deputy Commissioner had no option but to grant such previous sanction to the regrantee of the land by section 5 or 6 if he had better.
Yes.
That would answer. I would say. Now, actually speaking, Your Lordship, I only say if the regrantee is given an option of paying or not, in the interest of saving that land for himself and ensuring that the benefit does not pass on to the actual purchaser who had purchased it from him, he will always ensure that they won't pay the second. But the law does not seem to be in that direction. The law says that the benefit should come to me.
Yeah, I want to be at a board teacher position. I don't pay, right? You are not permitted to. Not what is not done in this case.
Not what the law says. It says that he is supposed to. Even otherwise, like this.
Yes. Para 6. Yes.
Yes, very good says, very good, not a donkey. It is required.
But then if the 1 gunta, the 1 acre of land, which is forms part and parcel of your.
We don't know where it comes.
So one.
Therefore, you are also already the purchaser or the question. Their question cannot be disturbed unless he says.
Then if there is no land in existence, then what happens?
Then you are also to see, yes, for declaration, open declaration, and declared for see for question. And now the two authorities have found it's not in
This
question.
court is thinking as to what would happen in the event this court comes to the conclusion that his sale has to be protected. And then the sale deed, what has been executed in his favor is not null and void. Then the sale which is done in the favor of respondent number 15 only.
If it is not available, it is really violation for declaration. See, what question on me? Not in question.
That's one thing. We have not yet framed, but we want to know what would happen in the. In the event this court holds the order of the Tahsildar and the appellate court not very proper in adjudication the matter and set aside the order of the courts below, the appellate court and the Tahsildar, then the sale deed which is there in his favor would be confirmed to that effect. And if at all he wants possession, that would be for him to approach the court. No, he cannot take any possession in light of an order passed by this court in a writ court. Like that.
Issued a legal notice intimating the record of the meaning of the sale. Willfully he has purchased the sale, going about the sale. Therefore, if his land is within the land that I am claiming, then he is bound, he is hit by section 52 of PP Act and is
No,
bound
we are
by-
not dealing with a civil suit here. So we are only looking into the provisions of the act, whether that has been followed and whether the order passed by the appellate authority, appellate court and the respondent number 1 was in accordance with this act. That's all we have to. No, that is not the adjudication because by this. It is a civil matter which. No, we will be in the event if this court holds in his favor, we can say that all the rights are being to be adjudicated. Civil. Heard reserved. Interim reserved, no, it will be there. Heard anta ಹೆಸರು ಹಾಕೋದು ಲಾಸ್ಟ್ ಟೈಮ್ ಹಾಕೊಂಡಿದ್ವಿ heard ಅಂತ ಹಾಕೊಂಡು reserved ಅಂತ ಅವ್ರ ಹೆಸರು ಹಾಕಿ. Yes, Mr. Bhandari. Ellie. What happened, Mr. Shekhar? That is what is. You are against the consequential benefits and other relief. They are against the order of granting relief in against. Password, no, password. 230. Let us see if he says something. ಇದು connected matter ಇಲ್ಲಿ ಇರ್ಲಿಲ್ಲ ಅನ್ನೋದು ಏನು ತಿಳಿಸಿದ್ದೀರಾ 5701 ಇಲ್ಲಿ ಇರ್ಲಿಲ್ಲ ಈಗಿದೆ ಇಲ್ಲ ಅನ್ನೋದು connected matter application ಇಲ್ಲಿ ಇರ್ಲಿಲ್ಲ ರಿಪೋರ್ಟ್ಸ್ ಕೆಳಗಡೆ ಹಾಕಿದ್ದೀರಿ Yes. We'll go to the second list. BC Prabhakar. What happened? There is possibility. Idea. Both the council submits that the parties are negotiating for settlement and would report settlement on the next date of hearing. Please this matter on Mangalwara. Tuesday. Come to the next page. Yes, ma'am. Just a minute. Yes.
Doing frustration here.
The petitioner is, no, the petitioner is a technical institute.
And the demands for rise by the first party workman. And there is no dispute at all whether they are workman or not.
That is not it. Petitioner is a technical institute. And the claim of the workman is that they are entitled for
the demands is arising.
they are entitled to the demands. Demands
Benefit of promotion on the basis of seniority. Time bound honest. Legal fact. I think the interpretation is for absolute damage. These are the demands which are right. And government also, I refer the matter under section 10(1) of the idea for adjudication by the industry private. They have given a list of 30.
you don't dispute that the petitioner is a private educational institute. If you don't dispute. Yes.
What are the I am not disputing the unrelated. More than what?
Yes.
So accordingly, I have raised a dispute, I have raised a matter before the Conservation Officer, as I have expressed earlier. The matter was referred to the court under section 10(1) of the idea for adjudication to the industry tribunal.
Yes.
The tribunal of giving the opportunity for all the both first part and second part. We have passed the court has passed the law. Then first part was for the entire. While passing the order, they have also referred about the rule 5 of the Karnataka Education Institute rule, as well as the observation was also there, and as well as the other observation pertaining to.
You have to submit this Karnataka Educational
I
Institution,
come to that part also.
whether it is
Yeah, I come
applicable.
to that. And the court also referred about Karnataka Private Education Institution Discipline Controls Act of 1974. The object of this act to provide for private discipline control over and all those things are. And that rule also. And it was also observation. But finally, your lordship, the court of taking the all aspects, including the application made by the evidence, application made by the second party witness. The court has passed an order, which is very clearly mentioned, especially in page 27.
Yes.
The award, page 61 of the therefore, it's not in its between involved. If there is a behavior, that is a relevant. Because former employees working are imparting and discharging their duties as a government. The institution of the government and the institution. The aim of both is to make society particularly imparting. Therefore, the employees in the private institution cannot be made discrimination in comparing with the employees working in the government institution.
These workmen are non-technical staff. They are not the.
Not patients.
So, teaching staff on parity is one thing, and non-teaching staff is one thing. Alva?
For the teaching staff, the faculty members in the technical institution, they are government agency.
So.
They will keep whether I am a you or I am a faculty.
Yes, sir.
As part of the institution, and part whether I am a good helper or a technical instructor or instructor also does the job. I am all non-teaching staff. I am part of the institution for the development. Ultimately, before the helper, don't instructor, and the whoever it is, institution cannot come here. It's not only the part of the teacher. I also have a equal.
Yes.
Take upon my qualification Other means that I should be treated differently than the teachers. For the purpose of service conditions of them. And for faculty members and the right faculty members, they have got layers regulations, they have been created. And it's also regularly updated by the government as per layers regulation. As they have, or even
Yes.
at least, how they are all admitted, I use the deadline. Therefore, it's not evidence, second part.
You are reading the para 14, right? You are reading para 14.
Yes.
When this being the law about discussed, it cannot be said that the government
Yes.
orders notifications are not applicable to
And
the
from the next
employees,
slide.
workmen of the private education institute.
Next part.
Ah.
The young people who is working as coordinator in the management had denied the claim of the right of custom. With evidence of the chief examination itself, the institution has created facilities over the years with the other education system and evidence with the previously unreached. It is evidence and examination chief of the government circulars orders are not applicable to parties. It stays in that thing, it is not at all applicable whether to the instructor, teaching, non-teaching, anybody but that. But upon considering the cross-examination of W1, it is admitted that for last 30 years, the workers of non-teaching staff are members of the first party. And early in the year 1992, government demands was raised and faced in the second part management. And in this regard, the case went up to the Honorable High Court of Karnataka, which culminated in passing the order in 1497 of 2016, dated 389. The revision meant said appeal. John Bobo was filed by both the Workman and the second party management. So the Workman and second party benefits on par with the basic payment of the government for years with effect from 1/6/1997.
Correct. This is regarding the
And
pay scale.
yes,
Pay scale. Yes.
And of deducting the amount already paid, government shall pay against the interest. My lordship are pleased with an order. In view of the amount paid, so all the past of the learners in the church, 127 of 1995, dated 27th of November 1992, is hereby modified voting that the apparent members are entitled to the benefits on par with the payment of the government employees with effect from 1/6/1997 and of the deducted amount already paid, respondents shall pay the arrears within 8 months from date. One thing is correct. They are accepting that what is paid as and the demand which are raised here, they are all incident of service. Whether the promotion or the input advancement or the cash, they are all incident of service. That has to go along with my service condition, along with the PCL. There cannot be a discrimination that only PCL eligible for government employees, service incident of service and that cannot be dichotomy between. Therefore, in terms of the joint reporting, writ appeal was allowed. Therefore, the second party management stated that before the Honorable High Court, that whatever the benefits which the employees still part of the entire, the same should be provided along with the pay scales payable to the government. Therefore, now the second part is stopped from contending the first part of the are not intended to be as
Yes.
but the MDO aspect is the post of for the termination. So the demand right to the 1992 was the sort of basic need and there was an order to affect the benefits. But the MDO had never denied considering the demand of the first part of the project. The first point consider the evidence of MDO, which is as follows. You kept on promising the first part union in respect of the present of demand. Because of that, if possible, will meet this. The second paragraph. Therefore, MW1 never denied whether demands of the first part union, but stated it was possible for the MW1 admitted himself as he has given voluntarily the cross examination. Second party had been approved, and the second party can accept the first part. Therefore, the court, while giving evidence to MW1, admitted that second party financial will accept the second party financial. That financial constraints. What is the financial constraints? There is no evidence for the second party. The second party management is a big institution, got MCA both in graduation, diploma level. Certainly, second party has its financial status of audit methods to knowledge. But when a such financial statement sheet is not produced by second party before the tribunal, there is no evidence on behalf of second party management that the second party management is facing financial statement. Therefore, in this regard, the reason assigned to the MW that the second party is referring to a financial statement sheet is going to be based and it is the defense taken just for the sake of defense. Therefore, second party has failed to prove its financial constraints to meet the demands of the first party. Therefore, second party is rather to accept demands by the first party and if the regard therefore produces the evidence, the second party cannot seek its responsibility on basis of financial constraints. Next part. Second, admitted through the evidence available that everyone himself voluntarily stated that second party will meet all the demands with their policy. Therefore,
If possible, they would meet the demands.
So,
If possible.
they are not
Financial difficulty is one thing. What is needs to be looked in, whether they are entitled for the similar benefits of the government and whether government orders have to be. What is that? Agbodu andre if it is possible. If it is possible in law, anta, where will this MW1 know all this? Yes, next. Yes, yes. Yes. No, this has got large repercussions, not only to this present.
Type of service condition which they are giving you for the teaching and other staff. It is definitely not so much serious company. I am not teaching staff, not only work for
We'll consider.
last few lines. Therefore, based upon this admission, the second party is here to grant all the benefits as are entitled. But this thing with evidence revealed during the adjudication of the tribunal, the second part management shall pay and extend all the benefits as far as possible. Therefore, demand and the first part are to be just to be referred. Therefore, the claim service is liable to be allowed. Reserve the party. The current order adopted. So the intercept tribunal has not caused anything which is absolutely within the evidence because permission of law or anything. So I have not moved the aspect of judicial restriction. There is court can really go to the aspect whether there is any.
Now the question, the question is before this court whether we have to answer. Rightly, whether it has exercised its jurisdiction rightly.
After completing all the formalities, giving the student panel of party is next, let us go to the rules.
They have certain rules, this institution has. Where is the rules? Additional document? Yes.
Chapter 1.
Yes.
Things of pay and allowances shall be as prescribed by ASCP or state government from time to time as modified and adopted by the government.
So there has to be an adoption and modification by the governing body. So they have to adapt it. So that is one criteria.
That's it. So that's what where it said There is a very positive that problem body. The level even passes on. Can they make such a thought a discrimination? That's what does. Chapter 4, page number 5.
Yes.
For non-teaching posts, the selection committee shall, as constable to the manager, qualification, experience, scale of pay, etc. Scale of pay, etc. shall be as prescribed to the state government from time to time.
So you emphasize on that scale of pay, etc.
Etc. Because the demand which I have placed is not something which is so ever and good. There are incident of studies. When I joined a profession, when I joined an employment, I need to be unique promotion. That is the legitimate expectation. If I am eligible for a promotion because of COVID factors, I am entitled for 9 more awards. Earned leave is like entitlement. If earned leave is not an entitlement, earned leave is also entitlement. Family planning benefits also like entitlement. They are all part of the incident of studies. They all come part of the etc. When you look into their
Chapter 5.
chapter 5, what are the criteria that mentioned?
So according to you, they have adapted this.
Absolutely. Whatever the state government says, as per state government, everything is as per state government.
Yes. So the non-teaching post.
For the teaching post, this is as per ASAP.
So
for the teaching post, this is as per state government. They have also given the qualification, criteria, whatever, everything they have given. Everything is as per state government, nothing else. And they are also producing brief synopsis. They are producing.
Synopsis. Both of them. Synopsis. When did you produce the synopsis? Yes, it's available here. Yes, yes. Okay. Yes.
Time for the promotion is entitlement.
Para number 4.
6. Time for promotion is entitlement. They have not paid any such demand and they are working without making any demand for other things. So they cannot get it.
Yes.
Therefore, the time waiver is highly delayed. That is the nature. They are not right to demand. In this regard, the government order termination.
But the rules regulation itself is clear that they will say that it is applicable. So now they cannot say that it is not applicable.
I want to one more point.
Yes.
Paragraph number 9. The award of industry tribunal is vague and it is not specific and it is not maintenance. However, the employers of union can always oppose the institution for extension of benefits without taking the aid of the union and they can keep the leave. So, we want to again clause unfair labor. They are ready to individually.
So in normal circumstances, the private institution are not bound by the government orders if they have not adopted it. But in the present case, having adopted,
Hence, it's a service which is it was a
it is not like the normal institution.
and there was such a thing in the
But then they would now distinguish saying that it is only for the pay scale.
Now also very clear mention about that. And I want to say that one Supreme Court judgment. Secretary Mahatma Gandhi mission.
Mahatma Gandhi.
Pages improving the process of the private and academic institutions. Everything is there in detail. That's not difficult. It's any detail.
Yes.
The judgment, what are the important functions of education institutions? How we there cannot be any classification or discrimination. And everything has been done in detail.
In this also regulations have been considered.
Yes, regulations have been considered, but then you have to ask for paragraphs.
Para number? Yes.
Then 92 to 95, 92 to 96.
At the outset, we make it clear that at least one so far as not governments have no excuse for making such a thing.
Another authority is violence. Another self agreement, and I should agree to this. Therefore, even otherwise, if the parents are obliged under the law, as we have already come to the conclusion, they are in fact obliged. That they are in fact obliged. It is for appearance to work out remedies and put the case in case arising out of the obligation to pay the device. What I'm saying is that this was under incident of obligation.
No, we need not look into anything but the regulations.
Next year. I also record about this. Bharat Bank.
Bharat?
Bharat Bank. But the employees of Bharat Bank.
There's one more judgment. Yes. Para number? So in this judgment of this Mahatma Gandhi mission and another, it is held that if the regulations. No, and the regulations provided that it
is also considered that what is accepted every in various modes of education.
No, now in this judgment of 2017 was a case of revised pay scale, but the regulation provided that they have to be paid pay scales and other service conditions to the teachers and other academic staff and technical.
I'm unaware of this regulation. I cannot be, I have not
unaided anta helidru, and this regulation is not applicable.
ಅದರಿಂದ ಇದು ಕೂಡ ಮಾಡಬೇಕಾಗ್ತದೆ.
Yes.
What are the models of industry regulation? Not only implementing the contract, they also can modify, add on the contract to make the industry contract absolutely necessary.
This is the rules, regulations, service rules of the Institute of Technology, right? Of theirs. Out there, no? Then what is that they want to distinguish now in this? What do they say now? How do they distinguish this, saying that it is not applicable to you?
What of prudence? I relied upon what of
No, they don't, they dispute this regulation. Then what they say? This regulation was part of the labor code. Why was it not produced? But you don't dispute that regulation, right? But then there is a regulation. Yes. Yes, yes. They say they're not implemented. Yes, fine.
And moreover, that's to be recognized in the meeting. The governing council.
It's been recognized. Services as per the governing meeting and that. And then? Yes. Yes. Hmm.
Next page of last. The powers exercisable by writing of this nature were considered in a judgment of penal code in India, Western India.
Where are you reading? Para 52.
52. Last one line.
The powers exercisable.
Power exercisable by writing of this nature were considered in judgment. In a judgment of penal code of India, Western India. Versus innocent tribunal. And it was observed that such a tribunal can do what no court can. They will add or alter the terms of conditions of contract. They will produce the judgment because very delicate.
Yes, yes.
Because they, whether even industry dispute can be an individual dispute or industry dispute, all things. Very well written judgment. What are the powers? To that extent.
Yes, yes.
One more question. Information. This social institution. Consider the weaker sections. Social administration.
Yes.
For example, the fixed purposes. Social welfare legislations. All the people to be treated equally. Let us go to para number 20. 21.
Yes.
Before concluding, we consider it necessary to observe the exercise use the ability to discipline. Outside the person, I put of legislation or social welfare in required to be there, you can include the source of the provision contains part of the law, which is what is the policy category, which mandates that the state should secure the social order, the promotion of welfare of the people, ensure equality between men and women, and equitable distribution of resources, subserve the common good, and also ensure that workers get their rights. More than 41 years ago, the chief opined that the concept of social and economic justice is a living concept of revolutionary thinking. It gives sustenance to the rule of law, and meaning and significance to identity.
Yes.
So we have the basic article contain a platform of promote social justice so that life of every individual becomes meaningful and is able to live human dignity. The concept of social justice is inherent in Constitution consists of diverse principles essentially for the ordinary growth and development of personality of every citizen. Social justice is thus an integral part of justice. Justice is directly realized to mitigate suffering, make colleagues diverse and different sections of society, and elevate to the level of equality by living the life of dignity of person. In other words, the aim of social justice attains substantial degree of social and political equality is the legitimate export of social.
Yes.
This is not making it compulsory. You need to be over. But in any case,
So that is all settled proposition. So we will not look in the same social welfare. Yes.
short, one is matter.
Short,
Very much matter of the state. By lab assistants as non-teaching staff at the school. The public by respondent private college. But there is a school to that, the law daily basis. They also raise that they will raise it should be as per government orders. Well, paragraph number 4 is we are all about lab assistants.
Yes. Non-teaching staff.
Non-teaching. It's not a dispute that existing instruction. Issued the government have given them the right to play the case has to be a part of the government employees. The question is when there are no statutory rules and institution are relevant, I may not necessarily granted the repetition constitution. It's not an in view of the long line of decision of this court, holding that when there is an interest created by the government in an institution to impart education, which is the fundamental right of the citizen, the teachers who will impart education get an element of public performance duties as a consequence element of public responsibility that is proposed employees and a foreign government employees. In consequence, they are also entitled, they are also not entitled to current cases as the institution of the it is also not in the all the persons how have reformed. Since the appearance of existing upon enforcement of the right to the judicial pressure, the legal and state protection of the state has obligated to provide facilities and opportunities to people aware of the right to education. The private institutions cater to the need of providing education opportunities. But that's not acceptable. Even according to your course in the private institution, although it's entitled to seek enforcement of the orders issued by the government. The question is as to which forum one should approach. High Court has held that the remedies are under the industry. When the element of public interest is created, exclusively to the element, the teacher, in fact, you agree to the lab assistant, being the arm of the institution, is all sentence of the remedy provided under the 226 procedure. Jurisdiction part is very wide. You could get different positions. So they cannot be denied the state benefit to others accordingly. So this very important thing that they are also in their appointed duty with the state regulation in the private institution. They are also entitled to seek enforcement of the orders issued by the government. For the same set of workers, for the same institution, another set of workers, same demands for rights. By another set of workers, to another union. That was decided in the year 2000. And they have one petition. This was decided in February 2020. The demand is in
time bond.
yes, the same institution, the Karnataka Education Society, set of worker article, represented by different union board. ಆಡಳಿತ ವರ್ಗದ ಸಿದ್ಧಾಂತ ತಾಂತ್ರಿಕ ಮಹಾವಿದ್ಯಾಲಯ ಸೊ ಕಾರ್ಮಿಕರಿಗೆ ಟೈಮ್ ಬೋನ್ ಸೌಲಭ್ಯಗಳಿಗೆ ರಜಿಸ್ಟ್ರೇಷನ್ ಮತ್ತು ಬದುಕು ಸೌಲಭ್ಯ ನಿರ್ಣಯ ಸಮರ್ಥನೆ. So everyone accept that they have fact related to political support, also an observation and also passing order. I don't know.
That joint memo is filed in which petition? Which is that writ petition number? Writ appeal number?
Also produced along with the
Yes. Yes, 1497 of 2003.
yes. 10.5. This condition would also hold not only use when only things right order, but it's all allowed to do such. As compared to the non-retail employee of a corresponding post of government. If that is true, I do not see any reason why such employees ought to be denied benefit of time board advancement, promotion, and or encouragement of encashment of money in so far as the business is the right of the having worked for a particular period of time and it became their entire on meeting the required which is not it's so applicable to government orders. Once a basis of the government institution has been made applicable to these institutions, the time board promotion is also an insurance service which could also be applicable to those non-teaching staff. And what challenge?
Yes. Yes. Hmm. Yes. Yes. Yes, let us see what submissions, 163. 163, What is that you wanted to say? Whether they can argue once more, what is that? The council, yes. Now your colleague has already argued the matter. Let she argue. Yes. Let she argue. She has already argued. Yes. You have to tell about the two judgments which is against you, which is against the present institution. In similar set of facts, it has been held they are entitled for the time bond. No, writ petition order. Now what has been placed by them? Writ petition 10791 of 2012, which has been disposed of in 2023. It's the same institution. You can't say you're not aware. Anyway, we will see what has to be done. Check mark. It's your own regulations. Yes, you will never adopt. Now there is a rules, service rules of the employees of this institution, which is resolved in a governing body meeting on in the year 2010. And you have come to this chapter 5, chapter 4, chapter 5, it says, is that we have read.
State government from time to time has qualified and adopted the result.
Correct. Correct. It has now adapted. Then come to chapter 4. Chapter 4. Chapter 4.
Non-routine board selection committee select council by the management. Except the healthy respect of the state government from that.
Okay, then come to chapter 5. Finally, come to the non-teaching staff clause. It says workman, workshop foreman as per the government, state government. We are not talking about Sahe, we are talking about the state government orders. It is not you have to. You have adapted it.
We are not adapted. We are anticipating them. Because in the very chapter when we stated that as per the governing body. So
and this is not for the first time your stand is being taken. We'll impose cost on the institution here. This stand has been taken. This has been negated by this court, not once, but thrice. The claim of the institution that this government orders are not applicable to the private institution, particularly this institution. Similar orders were challenged before this court, not once, but thrice, and that has been dismissed. Yes. Yes. Not adapted. Yes. Yes.
Yesterday I tried to observe the Karnataka Civil Service signed on advancement recently.
This is a new ground made by you now. Not adapted the government. Yes. No. We have read it yesterday. No, we are not coming to any conclusion that you have to adapt. We are only going by the records, what is available before this.
Workman was also should be applied to us. Clearly says that it will be applicable to the government employees. So we did not apply to the respondent theory. And with respect to the respondent also make a submission that about basic staff they are extended the all because they have some respect participants. So we extend to all the things as per the ALTD. And from non-teaching staff, as I said before, my lords, they are adopted without following any restrictions. They have no qualification also. And for the promotion, my lords, they didn't get any evidence that they are entitled for that. Like whether they have a specific qualification for that. Especially the time of function, because they are not entitled to the very state government, it will be applicable to the government.
Yes.
Now,
What is that you're producing? What is that you want to say? Huh? What is that?
and also whether this
Course. Yes, yes. Yes. Hmm. No, that we know. What is the order passed? Joint memo was filed.
okay. Whether they want to take whether their patient is any other benefits are
Correct. Yes. Ah.
Those rules of the rules 1978 provides that the scale of pay of an employee of an institution shall not be lower than the scale of pay of an employee of a corresponding post in the government educational institution. It does not ipso facto mean that the benefit of employees is on any allowance. One set of employees to make a parity of pay grades on the principles of it has to be shown by such grades in the qualitatively and quantitatively to work which they do is the same type and rates of the counterparts. Same scales are readily service for getting the parity. Not only even the educational qualifications must be identical, it is well tested by the patients by the different grades to give respect of the employees having a different educational qualification. Therefore, when the outcome is doctrine of equal pay for equal work only refers to pay, not to other elements. With respect to government employees, they will come up with certain qualifications. But
Kindly read the portion, what you're reading.
Mahatma Gandhi Vidya
Ah.
was by of 1978 and that's the problem of this is very unlike working as not employees of the society who are the light of thousands and entitled to the pay. That cannot be lower than the one and this is the employee holding corresponding to the target. Therefore, it is clear from the opposite judgment also that employees in the private education institutions entitled to pay which are accessible to the employees working in the public institutions on the equal levels. That way, no one is the create their client for the other money such as SRA, and other outside the purview of the
Yes. Yes.
Pay means only the pay which is attached to the fee. It does not include any other benefits of the services. Because that comes to not produce judgment or respect better than the intention of the other service. All judgments only speak about the
Yes.
like judgment with respect to the person and something else.
Yes.
Even the decisions rely on the land cost factor, appellant safety, earlier, versus the reputational input project engineering and analysis. Should the writ of mandamus by the court against the private education institution, like the first respondent hearing.
This is a case of writ of mandamus. So this is not applicable. Insofar now the present petition arises out of the order passed by the Labour Court, Industrial Tribunal. Yes, next judgment. Yes.
Whether the evidence of party is the independent on the safety which may be available to the government employees are required to be done. In the case, here Sampath and others versus the Secretary Ministry of Finance and under this document in the
This is an autonomous body and the regulations are totally different. They don't adopt the government orders. So this is. Yes.
Even the adjudication institution of the monetary, they will not take any monetary benefit.
Yes.
Because based on what is 10.6.
Yes.
Paid by the IT network as salary and allowances. Payment to the employees of Garni are being paid out of the consultant conducted state or the Garni setting of right of the Garni or all the relevant. As the running and central government and Parliament has depended upon the grant and made by the state government. Now, so far, the observation made by the High Court was the amount available and that was the it cannot be a ground to extinction band of specific benefits is not a one-time payment. Band of specific the recurring monthly expenditure and there is a
Yes. So this is regarding the pensionary benefit. Yes, next. Yes. Yes. That's all. Yes. 2:30 for dictation. Yeah. Whatever they are entitled for in accordance with law. Only because you are asking for, we cannot demand the matter. Yes.
Without any evidence, they are reduced to cash. That's the data by the Tata.
We'll see. The afternoon for dictation.
I appear for the respondent in this matter, my lords. Request for a week's adjournment, my lords. I have to file citations, my lords, in this matter.
Yes, I think she has started the argument.
She
yesterday.
started arguments, my lords, but then I had not filed the judgments, my lords, 2022 matter, and today senior is on his legs for a part heard matter, my lords. It may be had next week, he'll reply.
Yes.
There are other citations, my lord. Senior, I have to brief the senior, and he's in a part heard matter. The reason I'm asking for adjournment is only that.
At request of Rupashri, is this matter for further hearing on? When do you want? Take the date of your choice.
Monday, my lords.
Monday.
Much obliged, my lords.
Yes, Mr. Shekhar.
I am for the respondent, my lord.
Misconduct, unauthorized absence, unauthorized absence. ಅಲ್ಲ ನಿನ್ನಿದ್ ಮ್ಯಾಟರ್ ಅಲ್ವಾ ಇದು ಎಸ್ಟರ್ಡೇಸ್ ಮ್ಯಾಟರ್ ಅದೇ ಲೀವ್ ವಿತೌಟ್ ಆಬ್ಸೆನ್ಸ್ ವಿತೌಟ್ ಲೀವ್ ನಿಮ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ 3 ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅದಲ್ಲಿ 2 3 ಇದೆ ನಿಮ್ದೆ ಆಯ್ತು ಮಧ್ಯಾಹ್ನ ತಗೊಳ್ಳಿ Another in the afternoon. Yes. We will see that. ಅಲ್ಲ ನೋಡೋಣ we will argue. ಅವ್ರದ ಇದ್ರೆ ನೋಡೋಣ ಅಲ್ಲ
ಆಯ್ತು ಸ್ವಾಮಿ
23.
Number 23.
Yes, Mr. Subramanya Bhatt. 2002. Let him start his act. So we have to end this, no, 2002. Then next Subramanya Bhatt. Next, the Subramanya Bhatt next matter. 24.
24.
So pass over. We'll take him. We'll hear him. Crush. Yes. Your Akrash. What is your name? Baswaraj. Guru Prasad.
Narayan.
Pass over. Yes, Mr. Mukanappa. Mr. Prabhakar. Subramanya. Mr. Bhargav. Why was it listed today? KBO. It was argued for some time. At request from both sides, we adjourn this matter for today. Is it not? 2014. We want the councils to complete their arguments in the old matters. Yes. Then tomorrow we are dealing with KVU matters. Tomorrow. Yes, government. What is this? Termination. When was our appointment? Abdullah Kamdali. 1983 was her date of appointment. And what was the termination for? 2011. And then what was her misconduct? What was the reason? Hmm. Oral basis, no? There's no appointment order. Now, when she has been appointed, according to you itself, in the year 1993, 83, then she has worked for 240 days preceding the year. No, now you say that she has there are two criteria, right? One says that she has to be appointed by a way of a proper procedure. In the event there is no proper procedure, there has to be a timeline. For certain period, she has been rendering the services. Third is the petitioner, that is the management, has to appoint directly. Now that is covered in this. She has been appointed directly. There is no time fixed in this matter. No time fixed. For certain period, she is going to be given this work. Is it so? No. Then second is she has to prove that she has worked for 240 days. But you don't dispute that she has been working in your institution from 1983. Then what is that you want to dispute now? Resigned. Then it means that she was working. Then what you dispute? What you dispute? Correct, daily wages. In the event, if she is working for more than 240 days in the calendar year, no, if she is working 240 days in a calendar month, you have to issue notice to her under section 25F. That has not been compliant. So for that reason, the labor code says the order passed or the order of termination is not proper and it has been set aside. So what is wrong now? Yes, madam. 25F, what does it say? 20F, sorry, ID Act. 25F's conditions precedent to retrenchment of workmen. No workman employed in an industry who has been in continuous service for not less than 1 year under an employer shall be retrenched by that employer until she has been given, workman is given 1 month's notice in writing, indicating the reasons. You have not given any notice. So then that was directed to be reinstated. Is it not? 240 days, how do you establish that she is not working for 240 days? They have established that she was working for a continuous service for 240 days. That's all. What do you say? What? Which is that appointment order? Your work. Who has admitted? ಒಂದು ನಿಮಿಷ ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ? 39 para number 16. ದಿನಾಂಕ so and so ದಿಂದ what is that they had challenged? Kanishta minimum wages. So this means that she was in employment from 1/4/2003 to 31/12/2007. No, that is one thing. During this period, when was the order of, was she refused this work? From what time? And when did that happen? What was challenged? 31/12/2011. 31/12/2011. This is for this 2003 to 2007. Again, where is the admission regarding that aspect? This is in so far as 1/4/2003 minimum wages she had sought and she had approached this court. So she was working during that period. But now she has to establish that prior to her termination, that is 31/12/2011, she was in continuous work service for 240 days. Yes. Any other evidence to that effect? The burden was on you to prove that she has not completed 240 days because she would only not have the muster rolls with them. They would not have anything with them. They would only say that she was 240 days. Initial burden is on them. They say that they are not in possession of certain documents which show that she has worked for 240 days. She can just say that because she is a daily wager. She can just say that she has worked for 240 days. Then the burden shifts on you to prove that the daily wager, that is the workman, has not worked for 240 days. How do you discharge your burden? There was no muster rolls. At least there would be an entry to her presence. So the burden which was there on you, which was shifted on you, was not true. appealing the legality and correctness of the judgment and award dated 30/9/2013 passed by the in ID number 8 of 2012 on the file of the Labour Court at Mysore, that is referred to as Labour Court for short. The Inspector of Sericulture, Government of Sericulture, is before this court in this writ petition. The petitioner is referred to as state and the respondent as workman for the sake of convenience. Petition under section 10(4)(e) of the Industrial Dispute Act 1947 was filed by the workman directing the state to reinstate her into service with continuity of service and payment of full back wages from the date of the refusal of employment to the date of the reinstatement into service with all consequential benefits. The averments made in the claim petition is that the workman was appointed as a sweeper on daily wages in the year 1983 in the government sericulture. The by it is the case of the workman that the government sericulture had denied minimum wages and she had approached the minimum wages authority directing the state to pay a sum of rupees 1,34,806, being the difference in the minimum wages for the period from 1/4/2003 to 31/12/2007 on 18/8/2011, and the state did not comply the order passed by the authority, which made the workmen to approach the minimum wages authority by filing a petition for recovery of the said amount. It is averred in the claim that in the meantime, the state illegally terminated the workmen from service on 31/12/2011 without issuing any notice, not paid any compensation. Not paid any compensation. Was not produced before the then where is her name? Srimati Karuna 2011. You have only produced till 2011. No, because in the year 2011 you said that she is not entitled to work, and then there is from 2010 to 2011 there is an entry that she has worked for 240 days. Only absence is April. Total days she has worked in January 10 days, February 10 days, March 10 days, 10. This is your calculations. Attendance register has to be there. What is that? Yes, we'll see. It is further stated that the mandatory requirements under section 25 of the ID Act has not been complied by the state, and by the state. It is stated that she has worked for more than 240 days continuously in every year till she was denied employment by the state. The counter was filed by the state contending that the workman was never appointed as a sweeper, wherein there was no post of a sweeper. And the state being a sericulture department is a government department which does sovereign functions of the food and as such it is not an industry and there is no relationship as an employer and employee between them. It is stated that the workman had filed an application under minimum wages authority for claiming difference of wages, and she did not come forward for work from 1/10/2009. And the state has already paid the difference of minimum wages from 1/4/2003 to 31/3/2007. And she has suppressed the material facts that she has worked up to 31/12/2011. Next. The labor court by the impugned order held that the workman has worked in the establishment for more than 240 days in a year. 240 days in a year, and the establishment has not complied Section 25F of the ID Act prior to terminating the service of the workman. And by the impugned order, allowed the petition in part. And the action on part of the establishment in refusing employment to the workman on 31/12/2011 was set aside and was directed to be reinstated into service to the post last held by her with 50% back wages from the date of termination to the date of reinstatement with continuity of service and other consequential benefits with 2 months from the date of this award becomes inclusive. First, the learned counsel appearing for the petitioner and the learned counsel appearing for the respondent. It is submitted. The respondent workman was taken for a temporary work for a limited period. And the daily wages was being paid to the respondent workman for the actual period she worked, and she has not worked continuously for 240 days in a year. And she has stopped attending the work and there was no termination. It is the submission that the question of invoking the provisions under Section 25F of the ID Act would not arise since the respondent workman has stopped attending the work and there was no termination. So, contra, the learned counsel appearing for the workman justifies the order passed by the labor court and submits that the workman has worked in the establishment for continuous period for the previous month during the preceding 12 months on daily wages and the same has been rightly considered by the labor court while passing the order of reinstatement, which warrants no interference. Having heard the learned counsel for the parties, the point that arises for consideration is whether the order of the labor court, the judgment and award of the labor court warrants any interference in the present facts and circumstances of the service of the workman employed on a daily basis was terminated, was the grievance of the workman before the labor court. The workman deposed that he had worked for 240 days during the preceding 12 months on daily wages. The workman let in evidence as WW1 and marked documents at Exhibit W1 to W4. Exhibit W1 is the W1 and W2 are the orders of the minimum wages authority, wherein the petitioner was directed to pay the difference of minimum wages for the period commencing from 1/4/2003 to 31/12/2007 at rupees 1,34,806. At Exhibit W1, it was observed that she was working as a sweeper and she is entitled to receive the difference of minimum wages, and that she has put in continuous service from 1/4/2003 to 31/12/2007. That is more than 240 years in a year. The management, the representative of the establishment examined himself as MW1, and it marked documents that Exhibit W1 to W7. W5 to W7 reflect the wages paid for the period of November 2002 to 2004 continuously. Exhibit W6 indicates the wages paid to the workman and that she was paid 15 months salary at a time. W7 is a letter addressed to the Joint Director of Sericulture stating that the workman has claimed for monthly wages, payment of monthly wages of rupees 375 and has to be disbursed. The material on record was considered and held by the Labour Court, holding that the workman has worked from 1/4/2003 to 31/12/2007. The workman was a daily wager and could not have produced the attendance register or the muster roll in connection with his service for burden of proving that the workman had completed 240 days. The burden shifts on the employer to establish that the workman had not worked for during the preceding 12 months at for 240 days. There is no materials forthcoming to indicate that the workman had not worked for 240 days, and the same was not discharged by the establishment. The Labour Court arrived at a conclusion that the workman has proved that she being a sweeper, she has worked in the establishment for 240 days in a year, and the nature of work entrusted to the workman by the establishment is severable from the sovereign functions of the state. And the mandatory provisions of Section 25F of the ID Act prior to termination of service of the workman has not been followed. The impugned order passed by the Labour Court does not warrant any interference, and accordingly, the point framed for consideration is answered against the petitioner, and this court passed the following order. This petition is dismissed. The impugned order passed by the Labour Court stands confirmed. ಯಾವುದ್ರಲ್ಲಿ ಸ್ಟೇ ಇದೆಯಲ್ಲ 59.3, 59.4, 59.5. Only interim order granted earlier is executed. You should be careful, Mr. Mohan Kumar, when you speak through the VC. You will be in your office and you will be talking among yourself. You should keep the. Yes. 20. No, we will take up ಅಲ್ವಾ ಏನಾಯ್ತು ಅದರಲ್ಲಿ and what gratuity ಅವೆಲ್ಲ ಇಲ್ಲ give gratuity and PF ಯಾವಾಗ ಈಗ ಮಧ್ಯಾಹ್ನ ಬನ್ನಿ we will complete. Yes, after that you come after that. Petitioner that the petitioner has taken back their petition. No objections with no objections on 17 to 17/4/2024 and submits that he is filing a memo for retirement. Petitioner to is granted a week's time. Will haktira. You're filing it today. Yeah. Size memo for retirement. Yes. The memo of retirement filed by the petitioner is accepted. Issue court notice to the petitioner, returnable by. Yes.
ಕೋರ್ಟ್ ಆಫೀಸರ್ 25ನೇದು ಏನಾಗಿದೆ ಮೇಡಮ್? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 25 ಏನಾಗಿದೆ?
ಎಲ್ಲ ಚೇಂಬರ್
ಯಾಕೆ ಏನಾಗಿತ್ತು ಅದು?
With your lordship's kind leave, may I make one submission, my lord? Your lordship, in serial number 23 and 24, I was told that the matters are passed over. We only moved the matter, my lord. Unfortunately, I'm down with the fever, and my senior is the person only working today, and he's held up in other court in a part heard matter, my lord. May I request these matters may kindly be, can there be direction to list the matter any day in the next week, my lord?
Yes, yeah, we inform the other side.
Then I'm online, my lord. I'm
So
listening.
we'll have, when do you want, madam?
In any day, any date in the next week, my lord.
It was today. You are not arguing. So you give a date of your choice. On that day, you have to argue.
Yes, your lordship.
This matter is of 2002. At the request of the bar, we had listed this matter on top of the list to dispose of the old matters. Yes.
Please, your lordship, please. Can it be on the next Monday, my lord?
Monday. Nice.
I'm grateful.
Request of the petitioner counsel.
Obliged.
Pass. Yes. What is there to say about your presence now? Yes. 46. Ah. 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 So he's consistently absent. 12th. So we'll dismiss your petition. Writ petition 35353 of 2019 is dismissed. No? AC this 57914 of 2018 is allowed. The order of the labor quota, labor tribunal. Labor court, the order of the labor court is set aside. The memo is taken on record and have. Yes, we'll pass on.
Pass on matter. This one, serial number 3. Chandrasekhar B.
Who appears for the respondent here? HV, na? HV Devraju is directed to accept notice for the respondent number 1. Petitioner counsel to serve the petition papers on the learned counsel. Issue emergent notice to respondent number 2. Ashtena? Then you are not seeking for that interim prayer itself. Yes. When were you sanctioned with the temporary connection? And that was continued up to date. Continue. And on the behest of whom the electricity connection is now disconnected? Yes. Petitioner counsel submits that the respondent number 1 had issued a sanction order dated 13/8/2013, and electricity connection was sanctioned to the petitioner. At the behest of respondent number 2, the colluding with the respondent, at the behest of respondent number 2, the respondent number 1 has disconnected the electricity supply, which was sanctioned in favor of the petitioner. It is the case of the petitioner that the petitioner has acquired the said property through an allotment made and through a sale certificate dated 10/8/1991. And she is in possession of the property. The refusal, next paragraph, the refusal bar disconnecting of the electricity connection to the petition premises without there being any default on part of the petitioner and without there being any violation of the conditions. The action on part of the first respondent is not justified. Respondent number 1 is directed to restore the electricity supply to the scheduled premises till the next date of hearing, subject to the petitioner continuing to pay the consumption charges. Agreement is dated. Agreement is dated.
21/9/2006 is the date of agreement. There are 3 items of the property worth 003 2 acres, 104 2 acres. The sales consideration is not 2.88 lakhs. 45 lakhs paid as an advance. 5,000 even 5 lakhs even prior to agreement to make the payment. Now, should first receive per party. Prior to declare the injunction on 3 stage reasons according to the Number 1, the agreement is not registered. Number 2, 2016 agreement, now they filed the suit in 2022, therefore delay. Third reason is the deficiency of the strong agreement, therefore no order could be passed. These 3 reasons. So far as the valuation and stamp is concerned, required an adjudication. If it is an imported or not a personal card, then has to be designed. Then registration is concerned, if agreement will not be compulsory registered one. If a delivery of possession is there, not under section 70 capital A, it requires registration. Suppose if it is not there, then I cannot press my point or the possession is concerned. It would not invalidate the agreement in any manner.
Now you are before the court seeking for you're before the court, before the trial court, seeking an injunction in your favor.
Yes,
and the basis for seeking injunction is the agreement to sale. Correct. The agreement of sale does not indicate any possession or. Then
I am asking the intention not to alienate the property by the other side.
not to alienate.
Yes, not to alienate. Whether intention is the property would not be developed in any manner. These are the only 2 intention I sought for. Possession is not an issue, it is not the cause.
So where is the reasoning of the trial court on that aspect?
That's only reason. This is the 3 reasons assigned by the trial court.
Please. Earlier you were granted temporary
Yes,
injunction.
the injunction was in my court. It was discharged after other side is declared and granted. Can I take your lordship to page 13?
Now the granting of any interim order by this court at this stage would be as good as allowing your appeal.
Now injunction suit. Because the granting temporary injunction is as good as granting permanent.
Correct. Now it would be as good as.
People would not be universally applicable. So far as civil litigation.
So you take notice for the respondent, ask them to let them be present. When was. The status quo order is the most dangerous order.
I think your lordship may kindly take clarity that was status quo regarding possession in nature of the land.
Not possession.
Not for the organization and
Not- Where is that ex parte order granted by the court?
Your lordship is now
Page number?
45. What is the transport system departure license to that?
45 is the
Order number page 45. The plaintiff has obtained an exportive order of temporary injunction from the court to the effect of INA. Page 45.
yes.
The plaintiff has obtained an exportive order of temporary injunction from the court to the effect of INA.
So two applications with I number 4 and
The lordship may send this blank status quo regarding alienation. Your development, of course, could be tested after other side is here.
then the third, then the senior counsel, Raj, M.R. Rajput, for the appellant. The case made out by the Leonard Senior Counsel is that the appellant instituted suit seeking for specific performance of contract of an agreement dated 21/9/2016 in respect of the suit scheduled property, and the sale consideration was fixed at rupees 2 crore 88 lakhs. And the plaintiff has paid an amount of rupees 45 lakhs as an earnest money. Along with the suit, two applications were filed, I number 4 under order 39 rule 1 and 2, read with 151 CPC, seeking an ad interim order of temporary injunction to restrain the defendant number 1 and its agents from alienating suit C scheduled property or creating any third party right in respect of the said property. I number 5 and I number 5 was filed by defendant number 1 under order 39 rule 4 CPC, seeking to vacate the ex parte order of temporary injunction dated 19/8/2023. The senior counsel submits that the appellant had the benefit of an ex parte temporary injunction not to alienate the suit property. Item number 3, not to alienate C scheduled property. C scheduled property. The trial court on the 3 counts rejected the application filed by the plaintiff that the agreement dated 21/9/2016 is not registered. The plaintiff has approached the court with delay as the agreement was entered in the year 2016 and the suit was filed in the year 2023. And the agreement is not sufficiently stamped. That's sufficient. And by the impugned order, rejected the application filed by the petitioner, by the plaintiff appellant, I number 4, and allowed the application filed by the defendant number 1, I number 5. The order directing the respondent, directing the defendant was granted ex parte at the initial stage, restraining the defendant from alienating the suit property. The suit is for specific performance of contract. and the plaintiff is seeking for specific performance of an agreement of sale, which he states to have been executed by the defendant in his favor and in the said circumstances. And IA, the injunction order sought by the plaintiff restraining not to alienate the C scheduled property needs to be granted, as the third party rights would be created and would lead to multiplicity of proceedings. The said circumstances, the application file I number 1 of 2024 to restrain the defendant number 1 or his agents from alienating the suit property or creating any third party right in Schedule C property. As per the defendants and the respondent is restrained by a temporary injunction from alienating the Schedule C property till the next date of hearing. C property till the next date of hearing. Urgent notice, issue emergent. Only notice to defendant number 1. Memo is filed. Memo is filed by the petition appellant seeking for dispensation of notice to respondent number 2232. Memo is taken on record. A note is made in the appeal memo at page number 8, stating that the plaintiff does not seek any relief against respondents number 2232. The said submission note is accepted. Notice to respondent number 2232 is dispensed with at the risk of the appellants. Issue emergent notice to respondent number 1. On one order. So other order we are not granting, not to change. It's common order. ಇದು ಕಾಮನ್ ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ ಕನೆಕ್ಟೆಡ್ ಇದೆಯಲ್ಲ ಅದು ಆಸ್ತಿಸ್ ಕೊಡಿ ಮುಗಿದಲ್ಲ
My lord, I am.
Yes, you are filing an affidavit in respect of
Appellant number 6, my lord.
Yes. Memo and affidavit of appellant number 6 is filed by the counsel for the appellants. The appellant number 6 has agreed to vacate and hand over the vacant possession of the suit property, scheduled property, to the first respondent on or before 28 February 2026 and to pay and would pay the monthly rent at the rate of rupees 5,000 every month, starting from 1/9/2024 to up to 28/2/2006. The memo and the affidavit, undertaking affidavit, is taken on record. Appellant counsel seeks time to file the affidavits of the other appellants. Appellants 1 to 5 and Ashtena 1 to 5.
1 to 5 means, my lord, I have problem because my lord Deepu, who is my lord third appellant, is in Switzerland. I made a repeated my lord efforts, but I couldn't get. He is my brother. Not he is. I will file the affidavit of other appellants except my lord.
But then afterwards it will be a.
No, my lord. He is a software engineer. He is living in Switzerland.
Then later on he should not come and say that.
I take care of that, my lord. I take care of that.
Then you have to take care saying that the affidavit is filed on his behalf as well. You file the affidavit of one of the parties.
I have said so, my lord. In this affidavit, I said so, but I repeat it in other affidavits.
Yes. So when the final order is passed, we will call out those affidavit conditions.
Yes, ma'am.
Appellant counsel seeks time to file affidavits of the other appellants. and request list this matter on 14.
My lord, no, not 14th, my lord. My lord, is it on 19th or 20th? No?
Good.
My lord, till such time, let my learned friend may not proceed with the execution. I only request through the court.
23rd. Don't precipitate the matter.
Obliged, madam. I am highly
No,
obliged.
don't precipitate the matter in the execution petition. Shall we record or you will not? Yes.
Obliged.
Gentleman's word. Yes. Yes. Harish Pandari, he said he's got some parted matter. Let him come. Bare matter yavdo? You were ready in that matter. Nirmala. Shekhar ಅವರ ಬನ್ನಿ. ಎಸ್ ಏನದು ಎಷ್ಟು ದಿವಸ ಅಬ್ಸೆನ್ಸು? ಮೊದ್ಲು ಮಾಡ್ಲಿಲ್ವಾ? Earlier ಎಷ್ಟು ಸಲ? 12, 15, 16. ಹಿಸ್ಟ್ರಿ ಶೀಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಾರಲ್ವಾ? Have they produced the history sheet? But then that is not in dispute that you were held for certain charges. See, this absenteeism is the worst type of misconduct. once ಆಯ್ತು, once ಅಲ್ಲಲ್ಲ ಇಲ್ಲಿ. ಅಂದ್ರೆ ಯಾವಾಗ ಬುದ್ಧಿ ಬರುವುದಂತ. Yes, where is that Nirmala? ಮಾಡಿದಾರಲ್ಲ ಈಗ. They have taken ಅಲ್ಲ ಈಗ absenteeism ನೋಡ್ಕೊಂಡು they are doing reinstatement ಅಲ್ವಾ? ಅಲ್ಲ, corporation is taking the workman back into service. ಇಲ್ಲ ತಗೋತಾ ಇದಾರಲ್ಲ. Yes, madam. Nirmala.
Institute serial number 3.
What is his age? 41. Driver ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? When they don't come, without informing, they don't even inform. Matter of right ಅವ್ರಿಗೆ ರಜೆ ಅಲ್ಲ, ಮ್ಯಾಟರ್ ಆಫ್ ರೈಟ್ ರಜಾ ತಗೊಳ್ಳೋದು. 8-9 ಸಲ ಎಲ್ಲ ಮೈನರ್ ಪನಿಷ್ಮೆಂಟ್ ಕೊಟ್ಟಾಗ they should realize ಅಲ್ಲ ಅಲ್ವಾ? Correct. That's why we said, where is Nirmala? Nirmalan Karse. Where is Nirmala? She was present in the first hour, Allah. Password. Yes. We tell the court is of this view anta heli. Next.
Number 5. Ramesh Katyeka.
Yes, Mr. Annapnawar. Yes. Dictation.
Serial number 1. This is our
The petitioner management is seeking for the following reliefs. The appropriate government made reference for adjudication of the following points of dispute under section 10 subclause 1D of the Industrial Dispute Act 1947, ID Act for short. Page 36. Entire supplement. Para 2 no. The claim made by the respondent in its claim statement is that the management has not extended the benefit of promotion, time bond advancement, leave encashment and additional increment in respect of the family planning benefit to the workman, and in spite and further contended that all the government orders in respect of the above benefits are also applicable to the management, and the management is duty bound to obey and implement the said orders. The management countered the claim statement inter alia, contending as under time bond benefits, one month actually. 1A, fixation of seniority and time bond promotion. Extract matter, page number 16 and 17. Time bond benefits, that portion underline leave encashment benefit. Kindly be seated. What happened to the writ appeal? Yes. Next. Family benefit, family planning benefit. Number 5 underline ಮಾಡಿ. D ಅಂತಿದೆ ಅದನ್ನ extract ಮಾಡಿ. The labor code by the impugned award allowed the claim statement and held that the management shall pay and extend all the benefits on par with the government employees, and therefore the demands raised by the workmen by the union was found to be justifiable one, and the claim statement was live, but was allowed, directing the management to pay the benefits to the workman with 9% interest from the due date whenever the amount is due. The learned counsel appearing for the petitioner would mainly contend that the application of Rule 5 of the Karnataka Educational Institution, bracket terms and conditions of service, etc. Rules 1997 made applicable by the Labor Code, while passing the impugned order is not applicable to the petitioner, as the petitioner is an unaided institution, and the question of unaided private educational institution, and the question of granting benefits on par with the government employees would not arise in the present facts. The petitioner submits that the time-bound promotion is entitled by the workman. However, they have not made any such demand, and they are working without making any such demand for several years. And the claim made is highly belated. And the government orders, regulations, and notification are not applicable to them, as the institution is an unaided institution. 3. Regarding the encashment of leave, it is the contention that they are at liberty to utilize the earned leave, and the petitioner institution has never rejected any of the employees to avail the earned leave. It is contended that the benefits available to the government institutions cannot be extended to the employees due to financial constraints which the government has controlled, and the employees cannot insist upon such benefit. Next, that the family planning benefits, no one has placed relevant material such as local certificate from the revenue authority, regarding the status of the family, and therefore it was not granted. And the family benefits would be granted only to eligible employees who are entitled only upon production of documentary evidence at the appropriate time to claim the said benefit. That the employees union can always approach the institution for extension of the benefits without taking aid of the union, and they can seek relief like the others. That as rule 5 ಹೇಳಿದ್ದೀವಲ್ಲ ಅಲ್ಲೇ ಮಾಡಿ ಫಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್. Amenable as only an aided and not aided institution ಹೇಳಿದ್ದೀವಲ್ಲ. And that in order of the tribunal, the order of the tribunal imposing such measure on the private institution is impermissible, and that the impugned award passed by the labor court needs to be set aside. In support of her contention, you want the senior's name to be shown in the order? In support of this contention, Learned Counsel has placed reliance on the decision in the following decisions. Siddharth Educational Society versus Tumkur District in Technical Institution, WP 12937 of 1998. Susmita Basu and others versus Bali Bhunge, Shiksha Samitya and others. Appeal Civil 1468 of 2005. State of Maharashtra versus Bhagwan 2022 Civil Appeal 7684 of 2021. For contra, the Learned Counsel appearing for the respondent justifies the order passed by the tribunal and would contain that the workmen are entitled for time bond promotion, time bond advance benefits, leave encashment benefit, and grant of additional increment to the eligible employees under the family pension rules from the management, from the management from the management. And the tribunal has rightly considered and passed the interim order directing the management to pay the benefits. The respondent has placed the service rules of the employees of the petitioner institutions as resolved in the governing body dated 28/8/2010 to contend that in chapter 1 it is indicated that the scales of pay and allowances shall be prescribed by AICTE bar state government from time to time as modified and adopted by the governing body. Chapter 4 indicates that the qualification indicates that the scale of pay, etc., for the non-teaching staff shall be prescribed as prescribed by the state government from time to time. And chapter 5 shows the pattern, staff pattern and mode of recruitment and scale of pay is as per the state government. The When a council submits that the regulations deals with the pay scales and other service conditions to the teaching and non-teaching staff in the technical institution. And the regulations, at more particularly at chapter 5, indicates that the regulations are applicable to the teaching and non-teaching staff of the technical institution. And the scale of pay and other service conditions are as per the state government. The and that the government order which has been issued and produced by the workman before the labor court regards the time bond advancement of the employees of the education institution has been rightly taken into consideration, and the labor court has passed the impugned order directing the management to pay the benefits to the eligible employees. That in the writ appeals the tribunal that the settlement that in the settlement arrived in writ appeal 1497 of 2003, the management has which is that order, page number? Have you produced here? They have produced. Which is that? W12. As per W12. Sorry. As per W12. The management has accepted that the members of the union of the management are entitled for benefits on par with the pay scale payable to the government employees with effect from 1/6/1997. And now the petitioner cannot approbate and reprobate and contend that the pay scale and the other service conditions cannot be made entitled to the workmen on par with the government employees. In support of his contention, learned counsel has placed reliance on the following decisions. Bharat Bank Limited, Harjinder Singh, Secretary Mahatma Gandhi Mission, Krishnamma Charyalu versus Venkateshwara, Siddharth Education Society, writ petition 10791 of 2012. Writ petition 65310 of 2010, dated 9th February 2020. Having heard the learned counsel appearing for the parties, the point that arises for consideration is whether the award passed by the labor court is justified and warrants any interference in the present facts and circumstances of the petitioner management is a private institution, unaided private and an unaided institution. The regulations, the service rules of the employee of the management was resolved in a governing body dated 28/10/2010. And at chapter number 1, rule 4 reads as under. Chapter 4, rule C reads as under. Chapter 5, non-teaching staff post, non-teaching post, and non-teaching post. And extract column, page 8 of the regulations. Reads as under. Which is that paragraph you relied in Bharat Bank? The Yes, the apex court in the case of Bharat Bank Limited has observed that the tribunal shall have the same powers as are vested in the civil court under the Code of Civil Procedure Code when trying a suit, in respect of the following matters, namely, A. Enforcing the attendance of any person and examining him on oath. B. Compelling the production of documents and material objects. C. Issuing commissions for the examination of witnesses. D. In respect of such other matters as may be prescribed. And every inquiry or investigation of by a tribunal shall be deemed to be judicial proceedings within the meaning of section 193 and 228 of the Penal Code 1860. The apex court held that the powers exercisable by the tribunal by this nature was considered in the judgment of the Federal Court of India in Western India Automobile Association versus Industrial Tribunal. And it was observed that such a tribunal can do what no court can, namely, add to or alter the terms or condition of the contract of service. The tribunal having been entrusted with the duty of adjudicating a dispute of a peculiar character, it is for this reason that it is armed with extraordinary powers. These powers, however, are derived from the statute. These are the rules of the game that it has to decide according to these rules. Further held that the powers conferred have the sanction of law behind it and are not exercisable by reason of any discretion vested in the members of the The Labor Court gives a finding that the workmen of the union are entitled for the benefits and the government orders regarding the benefits are applicable to the institution. The While examining the order or award of the industrial tribunal, this court has to be this court has to keep in mind that the Industrial Dispute Act and the other similar legislative instruments are social welfare legislation, and the same are required to be interpreted in view of the goals set out in the preamble of the Constitution and the provisions contained in Part 4 thereof in general and Articles 38, 39A to E, 43 and 43A in particular, which mandate that the state should secure a social order for promotion of welfare of the people, ensure equality between men and women, and equitable distribution of material sources of community to subserve the common good and ensure that the workers get their dues. The apex court in the case of Mahatma Gandhi Mission and another observed that the regulations deal with the pay scales and other service conditions of the teachers and other academic staff in technical institutions. Regulations makes it clear that these regulations are applicable only to teacher and other academic staff to technical institution. And that the regulations have no application to the non-teaching staff employed in the technical institutions. Those such technical institutions are run with approval and other superintendents of AICTE. The regulations was considered by the apex court in the case of Mahatma Gandhi Mission, and it observed that the institution has no excuse for making such a submission, as in the earlier round of litigation, the respondent, non-teaching staff employees of the appellants, those succeeded before both High Court and this court in obtaining appropriate direction to the appellant and other authorities to revise the pay scales of the employees in tune with the Fifth Pay Commission, entered into settlement dated 31/2006, the terms of which have already been taken note in judgment at para number 4. Now, italic element. In the instant case, in writ appeal, 1497 of 1497 of 2003. W against the order in WP 12937 of 1995, the management Siddharth Education Society has entered into a joint memo, and the order of the learned single judge was modified in terms of the joint memo, holding that the members of the union are entitled for the benefits on par with the pay scale payable to the government employees with effect from 1/6/1997. The management has through a joint memo admitted that the non-teaching employees employed by the management would be entitled to pay scale of an employee of a corresponding post in the government educational institution. There is no reason or no material placed as to how the employees ought to have been denied the benefit of time bond advancement, promotion, or entitlement for encashment of earned leave when the regulations of the management clearly indicates that the scale of pay, etc., shall be prescribed by the state government from time to time. Though a contention has been taken by the petitioner counsel that the service rules of the employees of the management have not been given effect to. The materials, no materials is forthcoming, and the perusal of the service rules of the employees would indicate that it was resolved in the governing body dated 28/8/2010. Even otherwise, the contention of the petitioner, as indicated above, is that the workmen have not approached the management directly for seeking for such benefits, and the benefits claimed is belated. the petitioner has made out no ground to interfere with the impugned order passed by the industrial tribunal as the industrial tribunal, and the point framed for consideration is answered in the negative, and the court passed the following order. The writ petition is dismissed. The impugned order passed by the labor court can confirm. The decisions place reliance by the learned counsel for the petitioner is distinguishable and not applicable to the present times. Everything on the earth you cannot make a submission. Yes, yes. Yes, we will see. Yes. Yes, we will say that. Petitioner counsel, the pay scale does not include other emoluments. That is not even your contention in your claims, in your counter. Is it that, is it there in your counter statement, any of these facts? Any of the facts which you have been arguing before this court? There's no such contention, though no such averment is finds place in the statement of objections filed by the petitioner. Yes, we have already concluded, madam. Yes, next. Which is that? That is what writ appeal. Writ appeal they have filed on that. It is relevant to state here that in identical matter, the petitioner has suffered an order by this court, and the petitioner suffered an order by this court, and the benefits were given to the workmen of the union. It is submitted that the writ appeal is being preferred against the order passed by the learned single judge. However, there is no material to show that there is any interim order granted by the bench of this court. Yes. Yes, yes. We have not even said anything about 1986. Yes. Yes. Yes, you cannot say one thing in one court and come and say something else before the. Madam, we have already, we have heard you and passed an order. Yes, next. Yes. Yes, 3, Shekhar.
And for the respondent, madam.
Okay. Yes, Mr. Shekhar. Yes, madam.
My lord, let him argue, my lord. It is his case. Then I'll make a reply for that.
First time dismissal, we have heard him. You are not there.
Okay, okay, my lord. I'll make a reply, my lord.
No, not a reply. Look at this. First time dismissal for absence of around how many days? What is the date of
3 months? 3 months, my lord.
Why don't you give him a chance?
My lord, kindly he has failed to appear before the inquiry officer, my lord. We have sent the notice also. The notice has come back after 7 days saying that they could not find this person. And after
why don't you give him a chance of reinstatement now? Now that he is, why don't you give a chance of reinstatement? It's only a matter of 3 months. There are matters wherein the corporation is taking the workman into service in spite of there being long absence. Yes, madam.
My lord, I'm just making my submission, my lord.
But see, this is on merits. We are not asking you on merits. We are telling you that under similar circumstances and where the absence is more than this 3 months, the corporation has been reinstating the workman. Why don't you reinstate him?
Till the, is it going to be a condition till the disposal of the writ petition, or how your lordship is going to pass the order, my lord?
Madam, we are not asking you an order to be or dictated to be the court.
No, my lord. How your lordship is going to make
We
it?
are just asking you, will you take instructions from your corporation as to whether you will reinstate the
Yes.
work?
Yes, my lord. I'll take
Otherwise,
instruction.
pass orders on merits. Now that he has been dismissed from service,
Yes, my lord.
and there were minor punishment imposed on the earlier occasion, and this is the first time of dismissal wherein he has been absent for 3 months.
Yes, my lord.
3 months.
Yes, my lord.
So what do you, because
let-
under similar matters, the matters have been settled by the corporation saying that they would take them into service and they would see if he would mend his ways. That is all what has been lingering in the mind of this court.
My lord, kindly give me a 10 days time. I'll just discuss with
Not 10 days, you tell it tomorrow itself.
No, my lord, not because I have to contact the
Yes, yes,
one day.
Mr. Shekhar. Then if you are not inclined, we will
Kindly
see.
have it on Monday, my lord. Monday, by that time I'll ascertain it.
You cannot ask for 10 days, 20 days.
No,
You
I'll
should not. When the court is saying something to you, to get some instruction, you should do
Yes,
it at
kindly have it on Monday, my lord. I'll take instruction.
Monday. Request of respondent.
Much obliged.
Continue.
Number 4. Shekhar?
Yes, Mr. Bandari. Huh? 30. What happened? Serial number 30. Ah. Twenty Nalli. What happened? How much, what benefits will you give him? Only you're not paying him gratuity. Andre ಕೊಟ್ಬಿಡ್ತಾರಂತನಾ? If you confirm or set aside the order of the labor court, he would not be entitled for any benefits. ಅದಷ್ಟೇ ಅದು ನಾರ್ಮಲಿನೂ ಸಿಗತ್ತೆ ಅಲ್ಲ, ಅದಕ್ಕೆ ಯಾಕೆ ನಮ್ದು ಆರ್ಡರ್? ಅಲ್ಲ, this is compelling circumstances. ಅದೇ ಅವ್ರು ಮಾಡಿದ್ದೀರಲ್ಲ. ಹೌದು. ಇದ್ರಲ್ಲಿನೂ now he's been reinstated ಅಲ್ಲ, he was reinstated in this. ಮತ್ತೆ ಇದು ಅಲ್ಲ 95, ಇದು 2010, 5 ವರ್ಷ 95. Yes, yes, thank you. I to now see, now we have to set aside this order of reinstatement. Yes. Yes, Mr. Shekhar. Parity ಅಲ್ಲಿ ಬರಲ್ಲ ಅಂತಲ್ಲ, ನೆಗೆಟಿವ್ ಬರಲ್ಲ ಅಂತ. Identical. Negative ಬರಲ್ಲ ಅಂತ. Claiming equality in negative. Acceptance ಆದ್ಮೇಲೆ ರಿಲೀವ್ ಆಗತ್ತಲ್ವಾ? Circular says an employee intending to resign from the post held by him shall give notice of his intention to resign at least a month in advance, indicating the date on from which he intends to resign. The competent authority may accept a notice of less than a month if there are circumstances warranting such This condition is for the employee. Condition is for the employee to give a notice in advance stating that he wants to retire, he wants to resign, intending his intention to resign. His salary, he has to pay. See, this condition is for the employee here. Employee intending to resign. First is the employee should intend to resign from the post and should give a notice of his intention. This intention of the employee to resign. 1 month notice. Why? So that the employer can make arrangements for necessary other things in the absence of this employee. For that reason, this notice is necessary. And then the competent authority may accept a less than a month if there are circumstances warranting such acceptance. Now, in this case, you give a resignation stating that, please take my resignation forthwith. Takshana. ಅಲ್ಲ ತಕ್ಷಣ ಅಂತ ಇದೆ ಅಲ್ಲ ಅಲ್ಲ ಆರ್ಡರ್ refers to your letter. ಅಲ್ಲ ನಿಮ್ ಲೆಟರ್ ನಲ್ಲಿ ಏನ್ ಹೇಳ್ತೀವಂತ ಯಾಕೆ ಬೇಕು ಮತ್ತೆ?
Only when you are relieved from service. Today you are not relieved from service.
It was accepted. And he gives that amount of rupees 10,000 also he deposits. ಅಲ್ಲ ನೀವು ತಕ್ಷಣ ಹೇಳಲಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರು accept ಮಾಡ್ತಿರ್ಲಿಲ್ಲ. See, when a employee does not want to work, employer should not permit him to work. There is one more judgment of this court itself, of the coordinate bench of this court. Circular nalli, we have to, in the circular,
Workman was not relieved from service. Only when you are relieved from service.
ನಿಮ್ ಪ್ರಕಾರ acceptance. When was it accepted? 12 ಅಲ್ವಾ? What to do, Mr. Shekhar? This court is not very. Will say about it. But only thing now we ask the employer of yours, the corporation, to see if it can be. Now, if the order of the labor court is set aside, what happens, Iga? But he has worked alma, ishtu varsha kelsa madidare. See, he was working. That's if the claim is dismissed, he would get the provident fund which he has contributed even otherwise. He would get, not the gratuity and barala. Bartada? Even if you set aside this order, you will be entitled for gratuity. Then you are entitled. Now that he is already retired. ಅಲ್ಲ ಶೇಖರ್ ಅವ್ರೆ, ನಾವು ಹೇರ್ ಮಾಡಿದ್ದೀವಿ ನಿನ್ನೆ, just for the sake of doing something for the workman. ಅವಕಾಶ ಇಲ್ಲ, ಕಂಪೆಲಿಂಗ್ ಸರ್ಕಮ್ಸ್ಟಾನ್ಸಸ್ ಇದೆ, ನೀವು ತಕ್ಷಣ ತಗೊಳ್ಳಿ ಮತ್ತೆ ಬಿಡಬೇಡಿ, ನನ್ನ ಬಿಟ್ಬಿಡಿ ಅಂತ ಹೇಳಿದ್ದಕ್ಕೆ ಬರೋದೇನ ಅಲ್ಲ. ಮತ್ ನಿಮ್ ಯಾಕೆ ಇಟ್ಕೋಬೇಕು ಹೇಳಿ? Why should the employer at least keep the employee in service when he says, please take my resignation? Future date. ಹಂಗಿಲ್ಲ ಇದನ್ನು. ಅಲ್ಲ ಓದಿದ್ದೀರಾ ನೀವು ಶೇಖರ್ ಅವ್ರೆ, ನೀವು ಮಾಡಿದ್ದೀರಲ್ಲ ಯಾವ್ದು ರಿಲೆವೆಂಟ್ ಪಾಯಿಂಟ್? ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ಓದ್ತಾ ಇದ್ದೀರಾ? ಏನು ಮೆಂಟಲ್ ಸಿಕ್ನೆಸ್ ಸ್ಟ್ರೆಸ್ ಎಕ್ಸ್ಟ್ರಾ ಬ್ರೈನ್ಗೆ ಇಷ್ಟೆಲ್ಲ ಪ್ರಾಬ್ಲಮ್ ಆಗೋದೆ. ಆ ಬೆಂಚ್ ಅಲ್ಲ ಕೋಆರ್ಡಿನೇಟರ್. ಹಾ
Considering the fact of this case, I could be satisfied that the legislation has been tendered by the petitioner. The arbitration should have waited for a month before accepting it. This is the law declared by the summons. If there are compelling circumstances,
what according to you is the compelling circumstance? Compelling circumstances is when he says please relieve me ಅಂತ ಹೇಳಿದ್ಮೇಲೆ that is not a compelling circumstance.
Compelling circumstances. ನಾವು ಬೇರೆ ದೇಶಕ್ಕೆ ಹೋಗ್ಬೇಕು, ಇನ್ನೊಂದು ಏನಾಗಬೇಕು ಅಂತ ಶಾಸ್ತ್ರದಲ್ಲಿ ಮಾಡಬಹುದು. ಮತ್ತೆ compelling circumstances, warranting circumstances, corporations should have indicated the same in the order of acceptance. That's why we now take up the order and the rejection.
ಹಾ ಹೌದು, ಅದರಲ್ಲಿ ನಿಮ್ ಲೆಟರ್ ಇದೆಯಲ್ಲ ಫಾರ್ಮ್ ಪಾರ್ಟ್ ಅಂಡ್ ಪಾರ್ಸಲ್ ಆಫ್ ನೀವ್ ಈಗಲೇ ಹೇಳಿದ್ರಲ್ಲ ಯು ಆರ್ ಗೋಲ್ಡ್ ಮೆಡಲ್ ಅಂತ.
ವೈಯಕ್ತಿಕ ಕಾರಣ ನೀಡಿ ಅವರು ರಾಜೀನಾಮೆಯನ್ನು ದಿನಾಂಕ 8/3/10 ಜಾರಿ ಮಾಡುವಂತೆ ಅಂಗೀಕರಿಸಲಾಗಿದೆ.
ಅಂದ್ರೆ ಎದಕ್ಕಂದ್ರೆ ಇದು ದಿಸ್ ರೀಸನ್ ಇಸ್ 8/3/2010 ನೀವು ಕೊಟ್ರ ರೆಸಿಗ್ನೇಷನ್ ಅವಾಗೆ ತಗೋ ಅಂತ ಹೇಳಿದ್ರ ಅಷ್ಟೇ ಇರೋದು. ಮುಂಚೆ ಡೇಟ್ ಹೇಳ್ತಾರ ತಕ್ಷಣ ಅಂತ ಹೇಳಿದ್ದಲ್ಲ.
ಹೇಳಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಬೆಂಗಳೂರಿನ ಮೇಲೆ ರೆಸಿಗ್ನೇಷನ್ ಅಂತಿದ್ರು
ಒಂದು ತಿಂಗಳು ಮುಂಚಿತವಾಗಿ ಮನವಿ ಕೊಡದೇ ಇರುವ ಪ್ರಯುಕ್ತ 1 ತಿಂಗಳ ವೇತನವನ್ನು ಮುಟ್ಟುಗೋಲು ಹಾಕಿಕೊಳ್ಳಲು ಹಾಗೂ ಅವನಿಗೆ ಸಂಸ್ಥೆ ಬರಬೇಕಾದ ಹಣ ಬಾಕಿ ಇದ್ದು ಅವನ ಸಂಸ್ಥೆಯಿಂದ Corporation should have indicated the same in the orders. Both are obtained in this case. As such, the issued order dated ethical will stand. Citizens will stand alone. It is not in dispute that the respondent has directed month salary when accepting the resignation of the petitioner. That itself shows that the respondent has made upon class 3 as accepted.
ಇದರಲ್ಲಿ ಮಾಡಿಲ್ಲಲ್ಲ, ಇದರಲ್ಲಿ ಮಾಡ್ಲಿಲ್ಲ. 1 month salary ಡಿಡಕ್ಟ್ ಮಾಡಿದಾರಾ?
Respondent is here for class C. Class C then. Even the entity of class C, as expected above, do not empower the respondent to reject the salary. What are the guidelines provided by the competent authorities may accept the notice of entitlement circumstances warranting such exception, as rightly pointed out by the lawyer consultant, I'm not able to see it. Accept the resignation immediately. So no indication is found.
ಅಲ್ಲ ಅದರಲ್ಲಿನೂ ತಕ್ಷಣ ಅಂತ ಹೇಳಿದ್ದೀರಾ ನೀವು ತಕ್ಷಣ ಅಂತ
ಏನು ಹೇಳಿಲ್ಲ, ಏನು ಬೇಕಾಗಿಲ್ಲ ಸರ್. ನಾನು ಹೇಳಿದ್ದೇನೆ ಅಂತ ಅಲ್ಲ. ಅದನ್ನು separate ಮಾಡ್ತೇನೆ ಅವ್ರೆ. I'm not able to see the circumstances which warrants corporation to accept the situation immediately. Election ಇಂತ ಮತ್ತೆ ಮಾಡಿ ಮಾಡ್ಬಿಡಿ ನಾನು ಎಲೆಕ್ಷನ್ ನಾಳೆ ನಾಮಿನೇಷನ್ ಆಗ್ಬೇಕಂದ್ರೆ no indication is found. No reasons are stated in Annexure A, dated 8/9/94. For acceptance of resignation of the petitioner. So, in the absence of the circumstances warranting immediate acceptance, resignation, I do not see any reason to uphold the order of the respondent corporation. The guidelines stated above clearly gives a procedure to follow. Except the resignation, the corporation has not followed the procedure. I am of the view that secretary has brought to the side. Not able to accept the contention of the learned counsel to the corporation that injunctions can be made between R, B, and C the guideline. My look, R, B, and C have to be read clearer. As they asked about the situation should normally be accepted, the least possible delay except that in certain type of cases, the last week provided for procedure to be followed in acceptance situation. Both God and fear and that. I'm not seeing any, they do not see how the corporation could accept the resignation immediately. Next day, in the absence of the warranting this exception, it's true that competent authority can accept a notice of example if there are circumstances warranting this exception. If that is so, order accepting resignation to deny you. First, the reason for accepting resignation. Next area is that however, I'm not able to accept the argument to the legal counsel for the corporation. Still I have second thought for the resignation. They have given a story that they have done. Here, my lord, the reason has not been assigned. Just the resignation could actually, my lord, by violating the whole circular order, my lord. I think the lord said it. Some of what my lord has that have to wait 1 month. Whatever the circumstances not warranted. Here, my lord, they are not waited for 1 month, not given any reason for accepting the resignation immediately. But the labor court, my lord, rightly pointed out always after consider the similar parties consider the case of Prasad, rightly set aside the order of resignation. And my lord, the matter favors equal example court for admission, my lord. And the request made by the corporation itself that they is reinstated.
Yes. Yes. Yes, Mr. Bandari. You have to satisfy what are the compelling circumstances that made you to accept the resignation. ಹೇಳಿ
Because we have not educated that education.
Yes.
No, it's not specified that I wanted to convince letter or lordship. No, it's not reproduced here.
What is not reproduced? Huh. Yes, yes. That is not finding place in your order past. That is his contention.
This signature. That's part and parcel of order. Because I recommended and moreover, the lordship is always was in 2010. The reference was in 2014.
2014, no? Yes. More of 40. Not for dictation. Yes, password. Yes. Morning. Yes. Yes, yes. Yes, yes. We want to complete those matters, Ashte. We have heard it, Anna. Yes. Is other matters, any urgency in other matters? Because there is a 4 o'clock, one parted matter going on. Ah. 46. Monday. Which is that serial number? 25. 25 was adjourned, no? 25 was passed over. Yes, yes. Yes, yes. Now, when do you want? 11th, list on 11. 40? When do you want? Monday. Monday. 33. Who is the party in person? No. Sachidananda K. You're ready? Monday. Passed over. Settlement, yes. Interim order granted earlier is extended to the next date of hearing. 31. Why? Ah. Who has to give, who is the contesting respondent? State government. This matter was heard for some time. So take this matter for further hearing. This matter heard. We will hear it once more. We heard it. Yes, heard the petitioner in counsel in part. To hear further. This matter on Monday for further hearing. Tuesday. Have we heard it? Tuesday. ಹಾ 47 ಏನಾಗ್ಬೇಕು ಹೇಳಿ ಗೀತಾದೇವಿ ಎಲ್ಲಿ ಯಾವಾಗ ಬೇಕು ನಿಮ್ಗೆ ಯಾವಾಗ ಬೇಕು ನಾಳೆ ಟ್ಯೂಸ್ಡೇ 10 ಹಾ ಮಂಡೇ 35 ಮಂಡೇ yes 32 yes 2012 when Monday Tuesday yes ಎಲ್ಲ ಡೇಟ್ ಇವತ್ತಿದ್ದೆಲ್ಲ ಮೇಲೆ ಬರ್ಲಿ ಆಮೇಲೆ ಆಲ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ನಾಳೆ ಅಲ್ಲ ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ಹಾ 52 50 is Monday 52 Monday yes now they say that is different circumstances here. They said immediately they want to be they want to resign. The resignation has to be accepted. If they accepted their resignation on 12. No, that is not the question. They have accepted this resignation before expiry of this 1 month's notice period which was issued to them. No, what was the compelling circumstances for the corporation to accept their resignation before before the expiry of 1 month? Was the question.
What has the right to give them? If it is the resignation, has the regulation. Then, if your resignation is given to be effective from a prospective date,
future date.
Then you are just accepted for that. If it does not indicate anything, but then if it just resigns without the notice period, employer can accept it.
That is how it is in this.
Relieved, then there is no problem of withdrawal. Before he is relieved,
if he withdrew.
Because they were created, it is rights in 2000, they noted this. We are special VRS. Now, special VRS, it is a resignation was to accept in terms of VRS. That was considered as and they said that is the contract they make a departure from the law of limitation and then say that the moment it is accepted and communicated, even though we have to leave the accepted, it becomes the contract is complete when it is accepted and communicated. That will not apply.
Yes. Now, in this case, he gives a retirement on 10/11 or some date, resignation, and then that is accepted on 12.
They have not given him. They have continued him. Before leaving, he can
withdraw the. But then the compelling circumstances in this case was. No, he said immediately, please relieve me from this.
They have not relieved him. If they are relieved him,
so the question is relieving. Please furnish that Balram judgment. Thank you. Yes. For further hearing tomorrow. Further hearing.
Krishnamurti Hathyagar.
Kodi. We asked everybody to go and only Hasyagar and what is your name, Mr. Prabhakar? So that you can argue your matter, we asked everybody to leave. You complete your argument today. Yes, ma'am. This is the judgment of the Kalburgi bench.
Virtually, it is an unregistered sale. Can be unregistered sale or agreement of sale. Now, element for the document and document for the purpose. An information of independently and even the judgment of Madras High Court and the level point of time put up. After Madras High Court, of course, interpretation of Madras High Court. Madras High Court. Consider all of the new process. He has better certain comparison. Yes.
The notes for it. Notes. You have given some synopsis.
Oh, okay.
Yes. Now, what is your suit for? Suit for specific performance of contract. Yes.
In the fourth spring of 1997, is the appellant in this case.
Yes.
That is the suit for specific.
Yes.
Specific performance of the agreement of sale. Executed by dated 14/5/1995. Executed by Krishnadas.
Krishnadas?
He was the person who executed the agreement of sale.
In your favor, Radha. Yes. Radha. And then when Sarojamma files a suit for possession against Radha. And you are the defendant now in both. One is the plaintiff, another is the defendant. Now, what is that? On exhibit D8 is the agreement of sale.
Yes, the agreement D8. D8 is the mere.
ಇಲ್ಲ ಓದಿದ್ದ you all have already completed.
He is in possession of the from the year 1960. in virtue of her, and there is no was the tenant of the property as particular to the sovereign.
First you were the tenant. Then you say that you on basis of an agreement you have come on in possession. That is your contention. Now you have to be protected as a tenant or the specific performance. 53A you want to seek 53A. So even if your suit is dismissed for specific performance, you are entitled for the protection under section 53A. That is your contention. But now you have to establish that your possession is in pursuant to an agreement of sale and 53A has to be protected.
Some report that mediation it can be separate. ಅಷ್ಟೆಲ್ಲ ವರ್ಷದಿಂದ ಇದ್ದೀರಿ ಮೀಡಿಯೇಷನ್
ಈಗ ಏನಿದೆ ಅದರಲ್ಲಿ ವಾಟ್ ಇಸ್ ದ ಪ್ರಾಪರ್ಟಿ? They are not staying there. ಆಯ್ತು ಹೇಳಿ.
ಗವರ್ಮೆಂಟ್ ರೇಟ್ ಏನಿದೆ
ಆಯ್ತು. ಸಿ ಇಫ್ ಯು ಆರ್ ಸೇಯಿಂಗ್ ದಟ್ 10 lakhs ಕೊಟ್ಟು ಯು ವಾಂಟ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಹೇಳಿದ್ರೆ, ಅಲ್ಲಂದ್ರೆ ಇವ್ರು 10 ಲಕ್ಷ ನಿಮ್ಗೆ ಕೊಟ್ರೆ ನೀವು ಒಪ್ತೀರಾ ಅಂತ. ಇಟ್ ಶುಡ್ ಬಿ ವೈಸಾ ವರ್ಸಾ ಆಲ್ಸೋ. ಉಳ್ಳವರು ಇದ್ದವರು. ಯಾವ್ದಕ್ಕೂ ಯಾವ್ದು ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಇರಬಾರ್ದು ಎದಕ್ಕೂ. ಶುಡ್ ಲೀವ್ ಆಸ್ ಇಟ್ ಕಮ್ಸ್ ಅಂಡ್ ಇಟ್ ಇಸ್ ಸಂಬಡೀಸ್ ಎಲ್ಸ್. ಸೊ ಇನ್ನೂ ಬೇಡ ಅಂತ ಹೇಳಿ ಬಿಟ್ಟು ಹೋಗ್ಬೇಕು. And especially when you are a tenant. Agreement is held not proved by both the courts.
Agreement ಮಟ್ಟಿಗೆ they say that the signature they do not pay.
The reason is, let me tell you one thing. Tenant ಇರ್ತಾರೆ premises ನಲ್ಲಿ, ಏನಂತಾರೆ ಕಂಟ್ರೋಲ್ ಪಿಟಿಷನ್ ಅವರು ಬಿಡ್ಲಿಕ್ಕೆ ಬಿಡಲ್ಲ premises ಅನ್ನು. What the landlord would do, circumstances which prevailed upon the landlord to execute that agreement would also be one of the considerations. ಬಂದಿದ್ಯಾ? Without knowing what is the facts of this case, I am telling you what prevailed upon the landlord to make such an agreement or forcibly take such an agreement, because ಅವರು HRC ಹಾಕೊಂಡ್ರು. It's not that they had not initiated any HRRP ಆಯ್ತು, ಇಲ್ಲಿ ಬಂತು. ಮತ್ತೆ
he was in very financial. He did not run the anti-cost. They maintained that is counting the evidence of the son of I have two portions. Surprising enough, that was execution case, totally operating agreement. Since there are no strikes, I don't think it is last time I'm hearing.
ಅವ್ರು ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡ್ ಬಿಡ್ತಾರೆ ಎಕ್ಸಿಕ್ಯೂಷನ್. They say, huh? Nothing was submitted before the settlement. So that is very unbelievable anta helodu. Execution was
that is important to note because in the subsequent sale which was executed in 1998, vacant possession is given to you on paper. Then we have taken possession of the property. Later, if they have taken possession of the property in the year 1998 and in the evidence, I found out also, Karnataka said that Mr. Das did not take possession. That is why he assured that he will get evicted. But they change the story and they also say that the date is an execution is 6/10/1995. Oh, they possession on the army. This president of the BSC. That is how she is in possession. That is by way of amendment. They agreed in the evidence ಅಲ್ಲಿ they agree. ಆ ದಿವಸ ಪೊಸೆಷನ್ ತಗೊಂಡಿಲ್ಲ ಉಳಿದ ಸ್ವಾಧೀನ ನೀವು ಕೊಡುತ್ತೇವೆ ಹೇಳಿದ್ವಿ ಅಂತ ಹೇಳಿ and Deepak
one circumstances would be this way. Very unlikely a landlord would have executed an agreement in favor of the tenant, even otherwise in light of a compelling circumstances. I'll tell you one incident. There was a big house in one place. It was the ancestral property. A tenant was inducted in that house. The owner, the landlord, wanted to reside in that house, tried his level best to evict the tenant. He could not evict the tenant, but the landlord was forced to sell the property to the tenant. And the tenant was in premises of that property. Subsequently, landlord died due to the shock of his life because that was an ancestral property. He could not sustain himself. He died. Now the tenant who is in that premises, he is not in a good condition. He is come to road. ಅದು ಮೆಂಟಾಲಿಟಿ ಬಂದ್ಬಿಡತ್ತೆ ಅಂತ. So in one way or the other, the tenant wants to occupy that premises, maybe afterwards by taking in compelling circumstances from the landlord. Alla, you from when he is seeking for his property, 95. Alva?
Now 95 agreement
Allah, from when he is in possession as a tenant?
1972.
72 dinda he is fighting for a property of his. Allah, with the nature of yours, Mr. Hasyagar avare, this matter, whether it really needs to be contested.
That it is only on the basis of this.
ಹೌದು 14/5/95. allowed to continue saying.
But in the same thing.
Then when was he instituted?
1970.
72. When it reached finality? In execution.
94, 95.
So during that time, the execution was pending. So very unlikely that you would be in possession on basis of an agreement. You can say, but very heartbreaking thing in this. Very surprising. From 1972, this tenant could conveniently keep the landlord away from the suit property.
Oh, as well here, since they were close.
ಯಾವ ಫ್ರೆಂಡ್ಸ್ ಇದ್ರೂನು ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ 72 HRC ಅಂತ ಹೇಳಿದ್ರಲ್ಲ 72 HRC ಬಿಫೋರ್ ದಟ್ he must be residing from when before we were born also but ಇಷ್ಟು ಅಫೆಕ್ಷನ್ ಇಟ್ಕೋಬಾರ್ದು ಎದಕ್ಕೂ
This day, and she was national security. It is a learning point that she was national. Also called principle. Died on 15th of 1980. Even there are continue to be rational to power. Taking one effort to the point. So that is great that they will rational on 1995. A P700 position ತಗೊಂಡಿದ್ದೇವೆ. What it says is, you will find out in the
execution petition. Now this appeal is restricted to the extent of protection of laws under 53A.
And specific for province.
Agreement of sale is held to be not proved by both the courts.
That is because of the signature. How?
Correct. So that is fingerprint expert.
Our signature. The signature doesn't ID. We have admitted documents before this that even in admitted documents, T1 is the same that the signature is not your own signature. For example, my signature or the one to one of the signature earlier. That the state board has either take the existence of the expert or that the probabilities. The evidence given by the man. People will decide whether to take or what whether they are it's valuable.
Okay.
That is one of the questions raised by this. Whether the absence of any expert was justified in comparing the signature. 100% for 73 of the
Court has ample power. It can look into the admitted, and if it finds it is very different, it can analyze that. And the just difference is that it is obvious for the naked eyes to see it is different. The signature.
And that is one of the reasons why an application was not filed by the lender to refer the matter. And that part, he executed while marking execute. That was marked. It was marked. It was not objected by the sundown because Mr. was not relying on that. He was not relying. His hands, they did not object for the matter of the law. It was objected on the ground that it is not duly stand and it is rich.
Yes, all the.
By virtue of the agreement of say, dated 14/19, but the agreement continued to be production of the law. Next. Therefore, which stuff is related to our taken national.
ಅದೇ HRRP HRC ಅದೇ
And it is suggestion is made by Rojama that after the belongings were thrown away.
ನೀವು ಕುತ್ಕೊಳ್ಳಿ, they will not complete so soon. The execution is the possession, the possession is taken in accordance with law. Possession is
As per the document, as per the document.
correct. Whether it is now, according to you, it is only a paper document or it is not in fact not delivered, that is for us to be seen from the records. Records.
And I want to see and 1984. This is the document in one dated 14/19. I gave implementing our sanction in the name of students government. Why not get certificate to come? The same document, now another document. I mean, the now
No, this is not in dispute that you were in residing in the premises till the execution been delivered on 6/7/1995.
even thereafter she continued on their money.
ಅಲ್ಲ ಈಗ 14/1/1992 ನಲ್ಲಿ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀರಾ, KEB intimating power supply. That is not in dispute because you were in possession as on the date of 6/7/1995.
Even as of today.
ಅಲ್ಲ ಅದು
Because
ನೋಡೋಣ.
it is not possession.
ಅಲ್ಲ ಅದನ್ನು ನೋಡೋಣ.
It is not possession. Because
See, suit is for possession ಅಂದ್ರೆ protection of 53A is available not to take due course in accordance with law, other than in due course of law. ಈಗ possession suit ಹಾಕೊಂಡಿದ್ದಾರೆ. If you fail to establish your specific performance and your agreement of sale, then they are entitled for possession. ಅಷ್ಟೇ ಇರೋದು.
if is proved that the district will be by students.
Correct. Now, if you lose in your specific performance, this Sarojama is entitled for possession from you. Because possession suit is also here.
The same document and all of the documents have also been considered by the board. How my 8 years time was happened, I have been discussed without giving any reason. On 39 is all. I can on 5 number 3. All the financial institutions are available. How can get to the next? Yes. That's what rational thought of 7/1989. Of 89,000 My workshop is until
To Krishnadas.
Has allowed so because all the
Now, did you make, did you state in the execution petition that there is an agreement of sale executed in your favor and you are in possession pursuant to that? Please don't take your possession in it, under the guise of that HRC. Did you make any? The tenant appears to be very good.
Because it is there in the question that equal to 6,795. Paragraph expressly into the policy. Srimati is Rojama, weight is known as the second because she was disposed or the disposed. These established that the theory of disconnect by seeing the problem is imaginary and false. And Srimati that one that
Yes.
Yes. On 21/12/1997, what is number 927 of 1997 was filed by Srimati Raja. Yes. This is the date of the seeking for specific proposal the executive survey dated 14/25 executive DA. Srimati Rojama the subsequent the suit was filed. There was a lot of
One thing comes to their mind. Everything is linked. Possession HRC ಆಯ್ತು, agreement ಆಯ್ತು, possession deliver ಆಯ್ತು, possession ನೀವು immediately you say your basis of the agreement. Mastermind.
Suit file agreement. There was an order of status.
Alla. This agreement, immediately when he knows that the possession is going to be taken, there is an agreement here. Sandarbha. ಎರಡು ಕಾರಣ. Financial difficulties. When he says that there is an agreement, he would have told the court, no, I don't want to take possession because an agreement is already entered. That was not so. He took the possession after the agreement. Yeah, he has taken possession. Otherwise, even he would have made a submission to the court in execution. He did not. Because according to you, he was in good terms with you. He had taken amount. It is not even much of a difference when the execution was possession was taken 6/7/95. Yours was 5/7/5. That is May 95. No, perhaps he must have not stated. Ella hinge 16/5/95 agreement, 16/7/95 execution. If he had some ill will to you, he would have not said about this. He would have. He's taken possession now of the property. If at all an agreement was really executed by him, he would have said in that execution, no, I've entered into an agreement. Now I don't want to continue this execution. Please dismiss this execution petition. It is not so. There is no ill will for him for that time in span of 2 months. This is all, yes, that is how this court has to. Specific of there was no stay. See, her right would come only when the agreement of sale is held to be not true. Krishnadas LRs are here, right? Krishnadas LRs are here. Yeah, there. Yeah, LRs. ಇಷ್ಟು ವರ್ಷ 95 ದಿಂದ 72 ದಿಂದ ಮಾಡಿದ್ರೆ ಮತ್ತೆ ಎಷ್ಟು ಬೇಕಲ್ಲ.
It is very rare to hear that after the suit was filed, there was a lot of status for the defendant of the suit who had notice of the suit when it was waiting for his cap is admitted by England one son of Sudas in his evidence. After examination conducted on still 2010, page 89. He said, I was not aware of the status quo, and he accepted. That is the statement made by his son Deepak, who is he defines the status order as by 1998, date of alleged sale, exhibit P1, independent of Sumati Proceeding, dated in US River, video release of 1999. Exhibit P2, the sale rate states that actual possession of the suit property is handed over to person. When he says that actual weight in possession is handed over in 1998, apparently that is also, and he has suppressed the fact that Srimati Radha is in possession. Because that is what is stated by Soyam also in their way. And with regard to circumstances, it is more probable that without suppressing this, supported by everything, suppressing this agreement, he sent the property. And 98 there is Dana the arrangement. They say actual possession has been received by us. If they have received actual possession, taken possession, then
now courts below have held that you are not in possession of the property.
Possession again
says that
possession again because that suit itself is for our suit of possession. 90 years of fighting on the way to possession. That 1988 last year, Radha disposes of me. She is trespassing into the property.
That is their ground taken.
She has trespassed.
So there is a trespassing after the
yes, and the actual possession of property is handed over to page 3.
Andre 98 is the sale deed. When is that possession redelivered?
Execution
ಅಲ್ಲ redeliver ಅಂದ್ರೆ ಅವ್ರು ವಾಪಸ್ ಇದು ನಿಮ್ಮವರು they took trespass the property. When was it? After the sale deed?
They say that they have
after the sale deed.
They say that it immediately after possession as per execution on
97. 95. 95.
He said even this case from trial court to theory of function of the theory of this. Is done by the other hand, reports that even after we had he continued to possess the option related to the amendment happened. He clearly and the applicant they find that basis for amendment. He observed the amendment. In the paragraph 3, it was made. The document says that actual possession is not a thing. And that's been the other thing possession.
Ah.
28/7/99. This suit is filed in 28/7/1999. Who was number? Figure rate of 99. So, though the sale date is from 9/1/1998, Stephen is below the filed OS and the people with the 1998. On this day, speaking of national issue, our funds we are in the play. Stephen is below the mark. This is as of now. Just all of this day. It is
When did Krishnadas die?
1982.
Krishnadas.
2005. 2005. That has come in the evidence of 2005. So I read that is accepted by 2005 yesterday. The date so how what you are even before the date class and it's not that's aspect even the data has said Union United of is
$550, huh?
Regarding national in the same she has taken actual that. In the same capacity, she says she has taken act. Whereas in three of them, on to important. Srimati Subramanian did not say that she was discusses with her.
Yeah. Yes. No. Those.
Exactly. Apparently, it's more by convenience. It will go on line with the contents of she has put up that story that admitted even about the as admitted by Srimati Solam in para 7 of her play. Srimati Raga has been found the members of the friend. Observed by the dated 7 he's not
A date of Krishnadas.
When these figures and legally one in the case, he is responding to one of these legally one. This is not made out this is and other class of rare and before the entry model.
Order of
Order.
DA. Exhibit D8 is the document which you place reliance, agreement of sale. Possession was
Not on the ground, it is not in by Sudha, but on the ground, that it is not released.
not duly signed and that is for them to prove in the evidence. Now, they can object for the marking only on the ground that it is insufficiently stamped.
I was at the time of considering this objection. Because it was marked with 2 DW3. The approval is marked with the
Our admission, when marking of documents, whether he has signed or not signed, that would not be the question. The question would be only to the limited extent about the executability of that document, whether it was duly stamped or sufficiently.
The reply notice that you have responsibility to property subsequent to the alleged delivery of next as per teacher. And this aspect that is signature
ಎಷ್ಟೊತ್ತು ಮಾಡ್ತೀರಾ?
How much you will argue? ಎಷ್ಟೊತ್ತು ಮಾಡ್ತೀರಾ ಹೇಳ್ಬಿಡಿ ಅಂದ್ರೆ so that we can make the court available for. ಹಾ ನೀವು ಅಷ್ಟೇ ನಮ್ಗೆ ರೆಲೆವೆಂಟ್ ಎವಿಡೆನ್ಸ್ ಅಷ್ಟೇ ಓದಿದ್ರೆ ಸಾಕು. Synopsis you just ಅದ್ರ ಪ್ರಕಾರ ಅಷ್ಟೇ ಹೇಳ್ಬಿಡಿ. Another 1 hour. 1 hour. Is how much time you take? ಅಷ್ಟೇ ಅಲ್ವಾ? 1 day ಅಷ್ಟೇ ಮಾಡಿ ಇನ್ನೊಂದ್ ದಿವಸ ಮಾಡಿ ಮುಗಿಸ್ಬಿಡಿ. ಇವತ್ ಕಂಪ್ಲೀಟ್ ಮಾಡ್ಬಿಡ್ತೀರಾ? ಇವತ್ ಕಂಪ್ಲೀಟ್ ಮಾಡ್ಬಿಡಿ. ಅಲ್ಲ ಇವತ್ ನೀವು ಕಂಪ್ಲೀಟ್ ಮಾಡಿ ಅವ್ರದ್ದು ಕೇಳೋಣ ಆಮೇಲೆ ನಾಳೆ. Then we will pass orders. ಮತ್ತೆ ಮರ್ತೆ see we forgot in the span of 1 week. ಈಗ ಯಾವ ತಿಂಗಳು? 13th is Friday. This is full week ಇಲ್ಲ. Then if you complete it today, we will sit and if you are comfortable, you complete it. We will hear you and then ಮತ್ತೆ ಅವ್ರು ಕೇಳೋಣ. ಮತ್ತೆ ನಿಮ್ದು ರಿಪ್ಲೈ ಇಲ್ಲಲ್ಲ? ಹೇಳಿ. ಹಾ. Order of the 23/10/2010. 23/10/2010. Order on execution of communal sale agreement. It is 425/1995. 23/10, the agreement sale. ಇದು ಎಲ್ಲಿ detail order ಎಲ್ಲಿದೆ? Detail order, where do you get? It must be there somewhere here. Allah, detail order of this order dated 23/10/2010. No? The sale agreement dated 14/5/1995 is placed by the defendant by name so and so is impounded. Impounded ಅಂತ ಹೇಳ್ತಾರೆ. ಅದಾದ್ಮೇಲೆ ಇವಾಗ ಇದರಲ್ಲಿ ಹುಡುಕಿ ಅದಕ್ಕೆ. It must be there in the records. Yes, yes. Need the first defendant. ಅವ್ರ ಹತ್ರ ಕೊಡಿ. relied upon one more decision.
And it is not limited to this case, the remaining.
You paid the deficit duty and penalty. Aitala. So that has been considered.
As possession is and the first people in also until
It is clearly held that as the possession is transferred and even first defendant also conceded this aspect, they are ready to pay the insufficient stamp duty. And then it is clearly held, clearly held.
no aspect of imagination is being taken as it can want to be correct. You can say that is clearly that as possession
Document-nally, the possession is transferred and the defendant therein euro ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ. So insufficient duty is. It is not a view of the court, neither anybody's admission.
possession is delivered.
And that is how you require to be registered and pay the sufficient stamp duty. Alva. So that is the reason for what you have to pay the stamp duty and penalty. So possession doesn't mean that it is admitted by the defendant in the course of the evidence before the court. It is in the normal circumstances in that agreement. Insufficient stamp barudilla because you have already paid the stamp duty.
That this is also not be broken to or the reason that stamp duty is signature do not the stamp duty and it is not signed by the purchaser. Purchaser the signature ಮಾಡಿಲ್ಲ that is one graph. That CHs and it is not registered. These are the three terms on that will be paid. Each apartment affects not use them and I move. Then people say that patient making is here. There on the report that sentence more than I mistake in the
Yes.
We are not concerned. Next 44 category. 44 then, how 44 then? Paragraph. Every ಅವರ ಸಂಪತ್ತಿನಿಂದ ಅಡಿಗೆ ಮಾಡಿಸಿಕೊಳ್ಳುತ್ತೆ ಅಂತ ಹೇಳಿದ್ದೇನೆ.
Possession.
Yes. And yes, next
Page number 45.
ಮನೆಯ ಸೆಂಟೆನ್ಸ್ ಮುಖ್ಯವಾಗಿ ಆಸ್ತಿಯನ್ನು ಖಾಲಿ ಮಾಡಿಸಿಕೊಡುತ್ತೇನೆ ಎಂದು ಹೇಳಿದ್ದರಿಂದ ನಾನು ಒಂದೇ ಸ್ಥಿತಿಯಾದರೂ ದಿನಾಂಕ 1995
Yes, sir.
Next 105.
If you continue it on ಇವಾಗ 13 ಅಂದ್ರಲ್ಲ, let him continue it on 17. We have some orders to be corrected. You can come through VC otherwise. VC ನಲ್ಲಿ ಬರ್ತೀರಾ? So 10th you can come on VC. 12th to 12th. 12th. ಆಯ್ತು. 19 ಅವತ್ತಿಬ್ರು ಕಂಪ್ಲೀಟ್ ಮಾಡ್ಬಿಡಿ. Both all complete on that. 19. Calendar free. September 19 ಅಲ್ವಾ, ನೀವು ಯಾವ್ದು ನೋಡ್ತಾ ಇದ್ದೀರಿ? 19th ಅಂತ ಇದೆ. ಇದು ಅರಸೆ ಅಲ್ಲ? ಅದು 19th ಅಂದ್ರೆ ಇಲ್ಲಂದ್ರೂ ನೆಕ್ಸ್ಟ್ ಡೇ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಲಿಕ್ಕೆ ಬರುತ್ತೆ ಫ್ರೈಡೆ ಅದಕ್ಕೆ. Yes, no, we have some correction, some hand delivery is to be signed. Hello? Then it will be late. They will not issue hand delivery order. Then you produce, you ಹೇಳಿ ಯಾವುದು judgment. This two judgment. On 19th for further hearing. 2:30. 2:30. That is RSA second appeal day itself.